All right, good morning, everyone, and we'll get things underway. I'd like to call the Law Amendments Committee for Monday, March 27th, 2023 to order, and welcome everybody here this morning to One Government Place. My name's Brad Johns. I'm the MLA for the constituency of Sackville-Uniacke, as well as the Attorney General and Minister of Justice, and I'll be chairing for most of today's meetings. MLA Ritzy will also be assisting chairing. Just before we get things underway, I would like to ask all the members of the committee if they could please identify themselves, and we'll start with Minister Adams and work our way around the table.
Thank you. I'm Barbara Adams, the MLA for Eastern Passage.
Brian Wong, MLA for Waverley Fall River Beaverbank.
Good morning, folks. I am Kent Smith. I'm the MLA for the Eastern Shore.
Good morning, everyone. Dave Ritzy, MLA for Truro, Bible Hill, Millbrook, Salmon River.
Ben Jessam, representing Hammonds Plains, Lucasville. Good morning, everyone.
Good morning. I'm Braden Clark, MLA for Bedford South.
Gary Burrow, Halifax Shabukto.
Good morning, everyone. Susie Hanson, MLA for Halifax Needham.
Thank you very much, members, and I'd also like for the record to recognize Ledge Council that's with us today. To my right is Gordon Hebb, and to my left is one of the province's newest King Councils. I'd like to congratulate her, Karen Kingley. I'd like to ask everyone to please turn their cell phones off or put them on vibrate. I would remind anyone who's attending in the audience to please remain respectful during all presentations today. There to be no shouting or cheering either for or against what's discussed. If there is any disorderly behavior, you will be asked to leave. I'd like to remind everyone that there'll be no taking of pictures or video by anyone other than accredited media. Presenters are not allowed to use any types of props. If presenters do have handouts for the committee members, if they could please provide them to the pages, which are back here, and they'll distribute them to committee members. Copies of all written submissions on a bill that have been received by email up to the time when the bill is reported back to the House or in person during a Law Amendments Committee meeting will be given to the library staff to be posted online. Submissions received after a bill has been reported back to the House are distributed electronically to LAC members but are not posted online. All presenters today were required to provide notification to the Legislative Office that they intend to speak, so we'll be proceeding with a speakers list as provided by Ledge Council. The agenda lists the orders in which presenters will be invited to speak is available for viewing, I believe, just outside the door. When you are called to come and present, if you could please come forward, state your name, how you would like the committee to refer to you, any organizations that you may represent. If there are 8 or less speakers signed up on a particular bill, each presenter will be allowed to speak for 10 minutes with 5 minutes follow-up for questions from committee members. If there are more than 8 speakers, speaker 9 and onward will be provided 5 minutes to present to the committee with 5 minutes allowed for questions of the committee after their presentation has concluded. Particularly important because of the small room that we're in, once a speaker has concluded their presentation, I would ask that they leave the room in order to allow other speakers to come in and wait their turn. All speakers are welcome to return to Province House. I believe they have a monitor set up there where if you wish to continue to watch the proceedings, you can do so from there. So with that, I think those are the rules out of the way, so we'll get things underway now. We're going to go to our first bill. This would be Bill number 263, Public Utilities Act. We have no representation here, so I'm looking for a motion to close the public hearing. So I would go to MLA Smith, please.
Thank you, Mr. Chair. I move to close debate on Bill 263, the Public Utilities Act.
Motion to close public hearing. All those in favor? Opposed? I'd look for a motion to refer it back to the House. MLA Smith?
Thank you, Mr. Chair. I move to send Bill 263 back to the House without amendment.
Motion to move back to the House with no amendments. All those in favor, aye. Those opposed, nay. That moves back. Thank you. Moving on to Bill number 264, the Electricity Act. We have no representation for that, so I would look for a motion to close the public hearing. MLA Smith?
Thank you, Mr. Chair. I move to close public hearing on Bill 264, the Electricity Act.
Those in favor of closing, say aye. Aye. Those opposed, nay. And looking for a motion to move back to the House. MLA Smith?
Thank you once again, Mr. Chair. I move to send Bill 264, the Electricity Act, back to the House without amendment.
Motion to move back to the House with no amendments. All those in favor, please signify aye. Aye. Those opposed, nay. Perfect. So now we'll move into our third bill, Bill number 269, Construction Project Labor Relations Act. We do have some presenters for this one. Our first speaker would be Brad Proctor, and I'd ask him to come to the mic. Good morning.
Good morning, Mr. Chair.
So just for the record, if you'd identify yourself, if you're here representing any particular organization, and also how you would like to be addressed by members of the committee, please.
Great. Thank you, Mr. Chair, and thank you, committee members, and thank you to the Legislative Council Office for allowing us to speak. So you can refer to me as Mr. Proctor. My group that I'm representing here is one of the proponents who will be building a green hydrogen project in Nova Scotia, and that's Everwind Fuels. And that's who I'm here on behalf of.
All right, and so you'll have 10 minutes to present to the committee. You'll hear the little bell here go off when your 10 minutes is up, and then we'll follow up with 5 minutes of questions if any of the members have questions.
Certainly.
Whenever you're ready.
Thank you. And I'm here to speak in support of Bill 269 and not suggesting any amendments. Everwind Fuels is a proponent and plans to build a green hydrogen facility in Nova Scotia. We at Everwind have been dividing the construction of that facility into 2 phases. The first phase will be built in Point Tupper, Cape Breton, Nova Scotia. The second phase will be built in mainland Nova Scotia and in Cape Breton. The first phase consists of the construction of more of kind of a plant-based environment where there would be an electrolysis plant, an ammonia plant. For those who you might be familiar with the area, if they're familiar with the former New Star Terminal site, that is where Everwind has operations now. We run that site now. We have employees there, and basically that is where these will be constructed. So that will be phase 1. Phase 2 will be a onshore wind farm, and like I said, that's going to be largely on mainland, but also in Cape Breton. And the plan is that phase 1 will start sooner than phase 2. The key concept here is what we call green hydrogen. Green hydrogen is hydrogen made from a renewable energy source, so in this case, wind. You may Google and see things referred to as blue hydrogen. That's hydrogen that's not made from the green renewable source. And of course, we take that hydrogen. I'm not a scientist, so I hope there's no questions on this area, but we take that hydrogen, and that hydrogen is stored in ammonia, so that ammonia can be transported within Nova Scotia, outside Nova Scotia, internationally, and used for energy. The actual specifics of the facilities being built in Cape Breton would be a 300 megawatt hydrogen electrolysis plant, a 600 metric ton per day ammonia production plant, a 230 kilowatt substation and power distribution system, and a marine loading pipeline for liquid ammonia and distribution onto vessels, and then the liquid ammonia will be shipped by vessel. The plan for construction would be that phase 1, which is in Cape Breton, would start in 2023. And we would estimate, these are estimates, that construction would be at least a 2-year period ending in 2025, Q4 of 2025. And the estimated cost of phase 1 is in the range of $1.5 billion. Phase 2, which is the onshore wind farm, which will start construction in 2024 and go until 2026, has an estimated cost in the range of $4.5 billion. And like I said, you can envision wind turbines. There'll be wind turbines both on mainland and in Cape Breton. In Nova Scotia, we have legislation, which we're here, Bill 269, to speak in support of, amending the Nova Scotia Construction Projects Labour Relations Act. And as that act is currently created, it defines what's called a designated construction project, and it defines that very narrowly to be a natural gas liquefaction plant. Well, we're not building a natural gas liquefaction plant, so we need an amendment to that. When that legislation came in 2016, there was a project, the Paramedicine project, which was underway, and hence the reason that the legislation refers to it in that way. And so, basically, what we have been doing since is that you're going to hear from some of my colleagues, and I call them colleagues and I call them friends. They'll be, not to steal their thunder, they'll also be speaking in support of this. But you're going to hear from Mr. Callum McLeod with the Nova Scotia Construction Labour Relations Association. We've already had meetings with them and done presentations, and we've received a letter of support from the NSCLRA in support of this project. The NSCLRA represents all unionized contractors, both on mainland and in Cape Breton Island. And we've also had discussions with the Cape Breton Island Building and Constructions Trades Council, and they're represented here today by my friend Ray Mitchell. And we're very much, I would call it a partnership that we're entering into with these other groups towards building this, and they're in support of this as well. In addition to that, Everwind has received its environmental approval. It's had consultations with other stakeholders and entered into agreements with other stakeholders, including a number of First Nations in Nova Scotia. So you might ask, why do we want this legislation amended? Well, to make it quite simple, when you build something, there are roughly 14 unions that have a piece of trade jurisdiction. You can think of an electrician, a carpenter, a laborer, and each of those unions have a collective agreement. And those collective agreements have different expiry dates, different schedules for hours of work. And so what the Nova Scotia Construction Project Labour Relations Act does, it allows you to basically designate one specific project and negotiate an agreement for that project. So there's no risk of one union's collective agreement expiring during the project. Everyone will be on the same shift schedules. Those are the reasons. And my client, Everwind Fuels, of course, in investing a significant amount of money in this project, they want to make sure that they stick to their construction schedule and that labor is managed on site. And so hence the reason why this legislation serves a very useful purpose, allowing us to build this in Cape Breton and in mainland Nova Scotia. And so many of the things that, there's the schedules, all of those things are all of benefit. What happens after, once again, if this legislation passes, it will allow us, as the proponent, Everwind, to serve a notice on the Nova Scotia Labour Board and all other affected labor organizations, the NSCLRA, the Cape Breton Council, and all 14 unions, and say, hey, we want to have a construction project labor agreement. The Labor Board facilitates a process. It allows for parties to object in that process if they feel that they shouldn't be part of it or they should be part of it. And ultimately, the Labor Board will then issue an order, and that order will grant the proponent, Everwind, the right to negotiate what we call project labor agreement. And when that project labor agreement is negotiated, Everwind is the proponent. My two friends that are next to present, they're the actual parties to that agreement. The NSCLRA on the one hand and the Cape Breton Council on the other hand. And in that project labor agreement, that is where we will address things like hours of work, health and safety, incentives for basically apprenticeship issues, allowing inclusive diversity in the workplace, respectful work environment, non-harassment. All of those things will get negotiated into the project labor agreement that is in place for this work project. And that project labor agreement will remain in effect until the project is done, and then it'll expire at the end of the project. So those are my submissions. Once again, I'm speaking in favor of the amendment. And I would, I have no further revisions to the amendment. And I would like to thank my friends with the NSCLRA. I would like to thank my friends with the Cape Breton Building Trades Council, the mainland construction trades. I would like to thank the Department of Priorities and Planning for the assistance it's given us in this. And I would also like to thank my friends at the Department of Labor for the assistance that they've given in this thus far.
Thank you very much for your presentation. I'll stop this for a second, and I'll open the floor now for questions from committee members. Are there any? There are not. I'm sorry, MLA Clark.
Thank you, Mr. Chair. Thank you, Mr. Proctor, for your presentation. You talked about EA approval and all, and that process being completed. I'm wondering, are there any other significant regulatory hurdles for the project, either at a provincial or federal level, or I guess municipal as well, that you wanted to highlight? Thank you.
There may
I'm sorry, Mr. Proctor, please. So in between, I'll have to say your name just so that the people that keep track of what's said know that it's you speaking. So, Mr. Proctor, you have the floor. Thank you.
Thank you, Mr. Chair. There are many regulatory approvals required in a project like this. You know, obviously one of the largest ones is the environmental approval, which has been obtained. This particular approval we would get from the Labor Board, if you will, for labor issues. There's other approvals, health and safety type approvals and things of that nature that would be needed. I will say that you know, my role in the project team is really on the labor front. I've not been involved personally with the environmental aspect. Another colleague of mine at our firm has been handling the environmental pieces. But as far as kind of major approvals, I would say really the environmental and the labor piece would be the biggest things that we need to have, because we have to negotiate. We have to give notice to the Labor Board, which takes time, and then negotiate, which takes time. And within a schedule, which is 2023, you know, we want to move quickly and make sure we consult with as many people as possible. So there are others, but they're not as big as the ones, the environmental and the labor.
Thank you, Mr. Proctor. Any other questions? If not, thank you very much for your presentation today. Thank you.
Thank you.
Moving on now to our next presenter, Ray Mitchell, please.
Thank you.
Once again, Mr. Mitchell, if you identify yourself for the members as well as how you would like to be identified. And if you're here representing a organization, if you could identify that as well, please. And once you're done that, we'll start your 10 minutes.
My name is Ray Mitchell. Please refer to me as Mr. Mitchell or Ray, if you like. And I'm here today representing the Cape Breton Island Building and Construction Trades Council. The Cape Breton Island Building and Construction Trades Council has been in existence since 1967. It's an umbrella organization that represents the interests of all the construction trade unions on Cape Breton Island. And in fact, its role is advocacy, and also it operates as a bargaining agent, which is to a large degree why we're participating in this process and have a relationship with the two proponents for these projects on Cape Breton Island, which you've heard Mr. Proctor, and he's here representing Everwind Fuels, and there's a second proponent, Beerhead Energy. And along with our employer partners, which are represented by the Nova Scotia Construction Labour Relations Association. So a role for our council in this is to represent all the unions in their relationships with the other stakeholders that I just mentioned. The construction unions on Cape Breton Island represent approximately 3,500 skilled craft workers. These workers bring to the construction industry every day, through their experience, skill, and dedication to their crafts, value to our province and to our economy. Their contribution, along with the contributions of our employer partners, and we do consider the employers our partners, and we consider the Nova Scotia Construction and Labour Relations Association our partner in labor relations in the construction industry. We believe, you know, in the construction industry, we are an important economic driver, both on Cape Breton Island and for the province as a whole. We're in a very fortunate position right now. You know, we're on the cusp of two major developments on Cape Breton Island, and these are the green energy projects, and you've heard from Mr. Proctor with regard to his client's project, Everwind Fuel. These two proponents are eager and well positioned to develop these projects, these industries here on Cape Breton Island. And as Mr. Proctor pointed out, these are multi-billion-dollar projects. They're going to create several thousand construction jobs. We anticipate as many as 3,000 construction jobs each project at peak construction. Along with the construction employment that's going to be created, you can imagine there'll be an incredible amount of spin-off jobs and commerce for both Cape Breton Island and the province. I think it's important that these two projects are both environmentally friendly. Mr. Proctor spoke to how it's a sustainable project because it's going to be wind-powered. And this is going to be, actually, as he pointed out, the dollar value of the construction of these projects, the construction value of the wind farms is much more than the plant or facility itself. This is going to bring a new industry to our province. It's going to really going to benefit the local and provincial economies, both in the short term and the long term. I'm glad to say that these two proponents have very progressive views on labor relations. They've decided, and they had the choice, but they've decided that they want to work with organized labor to get the construction of these projects done. And we're very pleased to be their partner in the construction of these projects. Now, through the Construction Projects Labor Relations Act, the proponents, organized labor, and our employer partners hope to negotiate project labor agreements which will ensure safe work sites with premium wages and benefits for workers. And these agreements will strengthen and demonstrate our collective commitment to apprenticeship and will create diverse and respectful work sites that will reflect and include all Nova Scotians. Our council is fully supportive of these two projects. We see ourselves as partners with Everwind Fuels and Bearhead Energy, our employers, and their accredited representative, bargaining representative, the Nova Scotia Construction Labor Relations Association, which is represented here today by Mr. McLeod. We want to do what we can to bring these projects to fruition on Cape Breton Island. The fact is, and you know this, the other jurisdictions in Canada and abroad are very interested in developing these industries. We don't have to look any farther than our neighbor to the east, Newfoundland and Labrador, which is very interested, very eager to have these types of projects in their province. We want to do what we can collectively to make sure these opportunities come to Nova Scotia. The Construction Project Labor Relations Act provides for project agreements. Now, project agreements in the industry, we commonly refer to these as project labor agreements, or PLAs, is the acronym we often use. And the PLAs create certain terms and conditions for employment that are specific to the particular project. So through this act, the parties intend to negotiate an agreement, a collective agreement, which will be specific just to their project and only for the duration of their project. So those agreements are separate and apart from our usual construction industry and area collective agreements. A key aspect of a project labor agreement is that it provides some security to the proponents, to the developers, that there won't be any labor strikes during the term of the project. And that's why the agreements are separate from our construction industry agreements. And we understand that that's needed by the developers and the investors to make sure the project goes to interruption or delay. And the organized labor is quite prepared to cooperate with them in that regard to make sure these projects come here. Currently, as Mr. Proctor mentioned, the Act only allows project agreements for the construction of liquid natural gas plants in Guysborough and Richmond counties, which meet certain conditions. And the purpose of these amendments is to expand the application of the Act to include green hydrogen production facilities and the related infrastructure, which is, of course, wind farms. Our council is satisfied that the proposed amendment to the legislation is an efficient way to facilitate the proposed projects and their labor relations components. The Department of Labor, Skills and Immigration have consulted with Cape Breton Island Building and Construction Trades Council and other stakeholders regarding these proposed amendments to the Act. And after a collaborative and effective consultation process with the department, for which we're grateful, the Cape Breton Council has pleased to advise the committee that it supports proposed amendments to the legislation and respectfully requests that the bill be reported back to the House without further amendment. So on behalf of the Council, I'd like to thank the committee chair and all the members to have this opportunity to make this submission to you this morning, and I'm pleased to answer any questions that you may have.
Thank you very much for your presentation, Mr. Mitchell. I will ask if there are any questions of committee members, starting out with MLA. Jessom, please.
Thank you, Mr. Chair. Through you, thank you, Mr. Mitchell, for your time. Appreciate it. I'm wondering, you referenced the bill as it initially stood, being specific to projects. I believe you said Guysborough and Richmond, thank you. Do the changes that are before us today enable a more open-ended scenario whereby proponents could more fluidly come in and decide on new projects down the road, or are there still, I don't want to say barriers, but restrictions in place so that a project like this, perhaps suggesting another part of the province, could pop up without having to come back to the legislature to establish this type of legislative change?
Mr. Mitchell?
This legislation is only available to really large projects. The legislation has a threshold for a total project value of at least $2 billion. So it's not often you're going to see a project more than $2 billion come to the province. These are, fairly rare. However, to answer your concern, there's another process that's available in the Act, and it allows for regulation to be passed to permit a project labor agreement if a project is of significant economic value to the province. So there's another route that currently exists in the legislation which can allow to address the situation that you've spoke to.
Thank you very much. I'll go to our next question. MLA Burrell.
Thank you. I was wondering about the other provision of these amendments under which non-unionized labor is not precluded on the project. Does this have the council's agreement?
It does.
Sorry, Mr. Mitchell?
I'm sorry.
Yeah, that's okay.
That's Section 18 of the Act. So there's proposed amendment in Section 18, but the only thing it changes in Section 18 is just it identifies the hydrogen projects, includes those. The provision with regard to the participation of non-union labor, that pre-exists. That was there anyway. So what happens in this model is that the negotiations will occur between the unions, who are reasonably expected to be working on that site, and the CLRA, the Accredited Employers Organization, which represents the employers. And through that process, it may be the case that it'll be negotiated, some of the work can be done non-union. The fact is, for example, on a site like this, an industrial site, some of the construction may be modular construction, and there may be components that come in from outside of Canada or outside Nova Scotia perhaps, and sometimes that type of module might require certain warranty provisions. So you may see a team come from away. They won't be members of any of the unions here, but their expertise and experience with this particular module will be needed in order to have it properly placed on site. Sometimes there may be a particular scope of work in the construction industry that for some reason it may be necessary or maybe preferred that it might be done by some non-union group from outside, most likely. So, but that'll be subject to negotiation. So there can be non-union participation on the project, but it's a product of negotiation between the unions and the proponent and their representative.
All right. Thank you very much for your presentation then.
Thank you very much.
Calling for our next presenter, please, Callum McLeod. Once again, if you would identify yourself for the record, how you would like to be addressed by committee members, and if you're representing any particular organizations or not. And then we'll start your 10 minutes.
Thank you, Mr. Chair. Callum McLeod, representing the Nova Scotia Construction Labor Relations Association. Mr. McLeod or Callum is fine. Thank you, committee, for your time. As I said, I'm with the Nova Scotia Construction Labor Relations Association, the NSC-LRA. We're the accredited bargaining agent for unionized contractors in the industrial commercial sector of Nova Scotia's construction industry. We represent and negotiate on behalf of roughly 300 contractors over the mainland and Cape Breton Island. I'm here along with my colleagues to speak in favor of Bill 269, an act to amend the Construction Projects Labor Relations Act. The Construction Projects Labor Relations Act allows for project agreements to be negotiated by accredited employers organizations and the bargaining agents for unionized tradespersons in certain limited cases. Currently, only for the construction of natural gas liquefaction facilities valued at over $2 billion in 2 specific counties, as we've said. The NSC-LRA has previously negotiated 2 such project agreements under the Act with the mainland and Cape Breton Island building trades. We feel that project agreements should be only applicable to those rare multi-billion-dollar projects such as the construction of an LNG plant. Having discussed these 2 proposed green hydrogen projects with project proponents, we believe that these are also the exact type of projects that the Construction Projects Labor Relations Act was intended to address. Construction of these projects is expected to take several years, spanning the expiry of our regular provincial collective agreements. And project agreements would allow the proponents the type of labor stability and extended work schedules needed to finance such a massive project. The NSC-LRA would agree that the definition of designated construction projects under the Act should be amended as per Bill 269 to allow for green hydrogen projects valued at over $2 billion, allowing the NSC-LRA and the building trades involved to negotiate project agreements under the terms of the Act. This Bill 269 simply adds green hydrogen projects to the type of project covered under the Construction Projects Labor Relations Act without otherwise affecting the function of the Act. We feel this is correct. The current procedure for negotiating project agreements in limited instances is appropriate and works well, does not need any adjustments. The NSC-LRA would request that the Law Amendments Committee approve Bill 269 as written without any further amendments. We look forward to working with our partners in the building trades, the proponents, and the Department of Labor to begin the process for negotiating a project agreement. Thank you very much.
Thank you very much for your presentation. I will ask if there are any questions from committee members, and I will go to MLA Burrell, please.
Thanks. So we understand that the scope of the mega construction also includes a big component on the mainland side. So to your knowledge, do these amendments have the agreement of the Mainland Building Trades Council?
Mr. McLeod?
Thank you. We've been speaking with the council, and they would be willing to work with us to negotiate a project agreement as well. I believe the only discussion with everyone right now is for a Cape Breton one, but a mainland one could be negotiated at a future date.
Thank you. Any other questions of committee? MLA Clark?
Thank you, Mr. Chair. Thank you for your presentation. I'm just curious, you mentioned 2 project agreements were reached in the past under this process. I'm just wondering, as an association, as a group, what was learned through that process that you might be able to apply for potential agreements coming forward?
And Mr. McLeod?
Thank you very much. Yeah, we did an LNG project agreement for the Guysborough County and Richmond County LNG projects. We've sort of learned, we've got a framework now. We've got 2 agreements on the books that we can use as a benchmark, so it's going to be easier starting, I think. The projects didn't go ahead, as we know, so in terms of lessons learned, hard to say, practical lessons, but in terms of the negotiation, we certainly have a sense. We were using, examples from other regions where they do project agreements more often, so we've adapted it for Nova Scotia now, so it'll be easier to start, I think, using the Paraday and Bearhead agreements as benchmarks.
Thank you. Any other questions? Thank you very much for your time today.
Thank you.
So with that concludes our number of speakers on this particular bill. I'm looking to members for a motion to close the public hearing on bill number 269. MLA Smith.
Thank you, Mr. Chair. I move to close public hearing on Bill 269, the Construction Projects Labor Relations Act.
All those in favor signify aye. Aye. Those opposed, nay. And I'll now close that and look for a motion to refer it back to the House with no amendments. MLA Smith.
Thank you once again, Mr. Chair. I move to refer Bill 269, the Construction Projects Labor Relations Act, back to the House without amendment.
Motion on the floor. All those in favor signify aye. Those opposed, nay. And that concludes that. Thank you. Moving on now to our fourth bill this morning. This will be Bill number 256, the Patient Access to Care Act.
We're early.
We are running a few minutes early, so we'll take a 5-minute break if members would like to grab a coffee or step outside for a sec. Or
Order. I'd like to, recall the Law Amendments Committee for today, Monday, March 27th, to order. Again, welcome everybody to One Government Place. My name is Dave Ritzie. I am the MLA for Truro Bible Hill, Millbrook, Salmon River, and I'll be chairing some of this meeting today as the chair has stepped out for a bit. I'll ask the members of the committee to identify themselves again. We'll do it one more time. We have some new people in the room, and I'll start to my left with MLA Boudreau.
Thank you, Mr. Chair. MLA Boudreau, Trevor Boudreau for Richmond County.
Good morning again, everyone. I'm Ken Smith. I'm the MLA for the Eastern Shore.
Good morning, Brian Wong, MLA for Waverly, Fall River, Beaverbank.
Good morning, everyone. I'm Barbara Adams, the MLA for Eastern Passage.
Good morning, everyone. Susan LeBlanc, MLA for Dartmouth North.
Gary Burrell, Halifax, Chebucto.
Good morning. I'm Braden Clark, MLA for Bedford South.
And to my right, I have Gordon Hebb, Legislative Counsel, and Karen Kinley. Is that right? Kinley. Yeah. There we go. Kinley. Sorry. To my left. So the agenda listing, the order in which presenters will be invited to speak is available for viewing on the corner of the table to my left. When your name is called, please come forward and state your name and how you would like the committee to refer to you, Mr., Miss, Mrs., and the organization, if any, that you represent. So presentation time, if there are 8 or less speakers signed up on a particular bill, each presenter will be allowed 10 minutes to address the committee. However, if there are more than 8 presenters on a particular bill, then each presenter will only have 5 minutes. I will alert you when you have 1 minute left in your presentation, and there will be up to 5 minutes allowed for questions from the committee. All right, so we're going to get started. Right now we are on Bill 256, Patient Access to Care Act. And I would ask the speaker, Raylene Langer? Langer, yes. Langer, okay. Welcome to the committee. Please, if you could, introduce yourself and any organization that you represent. Thank you.
Good morning, committee. My name is Raylene Langer, and I'm here today as a lawyer with expertise in the area of professional regulation, as a member of a regulated profession myself, but most importantly, as a member of the public interacting with Nova Scotia's healthcare system. I can be addressed as Ms. Langer. First, I'd like to begin by stating my concern with the lack of public, professional, and regulatory consultation in the drafting of Bill 256. And second, I'll speak to how this lack of consultation is clearly reflected in the bill's provisions, given its language, purpose, and lack of defined terms. Ultimately, I'm here to speak about the risk that these provisions create for patient safety, professional integrity, and public confidence in the regulation of Nova Scotia's health professions. To begin, I do not want the committee to lose sight of the fact that the regulation of Nova Scotia's health professions emanates from legislature, but in a different manner than in which this bill appears before us today. Prior to the introduction of Bill 256, the legislature granted the privilege of self-regulation to each of the regulated health professions that are impacted by this bill. In doing so, the legislature delegated decision-making authority to each of the professions themselves through statute. In granting self-regulation, the legislature recognized the immense institutional and professional expertise held by health professions' regulatory bodies. The legislature afforded these regulators considerable latitude in their respective statutes when it comes to the power to decide on the policies and procedures that govern their professions, the policies and procedures that maintain professional competence and integrity, and those that ultimately protect the public. The legislature further mandated all health professions regulators through their statutes to act in the public interest. Protection of the public requires these regulators to hold individuals who seek to be registered and licensed in the health professions to high standards of performance above and beyond what is generally required of individuals in society. It's difficult to overstate the importance of proper, well-thought-out, risk-based regulation of health professionals and monitoring professional competence, conduct, and capacity. This importance stems from the dangerous consequences of a failure to properly regulate health professions and the extent to which our public places trust in them. Government missed a valuable opportunity when it failed to consult the public and regulatory stakeholders. Members of the public are the ones who will ultimately be impacted by any risk that this proposed bill opens them up to, and regulatory stakeholders are the professionals who operate within carefully thought out and very intentional regulatory frameworks. They make decisions in the public interest every single day. I'll now speak to the specific issues created by Bill 256 from my perspective as a regulated health professional and my perspective as a member of the public. The first concern I have with Bill 256 lies in Section 2, its purpose, which states in part, ensuring all health professions can work to the full extent of their training. I'm a lawyer licensed to practice in Nova Scotia. I have lots of training. But I also know that this does not mean that I am competent to practice in every area for which I have received training. Similarly, I know that a physician who received training in surgery 20 years ago, but who has solely practiced as a family physician in the 20 years since, is not competent to perform a hip replacement. And I certainly wouldn't want that physician to be performing a hip replacement on me. However, the purpose provision of this bill appears to enable that. Further, there's no mention in the purpose provision of any of the key guiding principles that we see in other regulatory statutes in Nova Scotia. There's no mention of competence, of safety, or of the public interest. And indeed, there is no mention of safety at all, not even once, throughout this bill. I'm left wondering whether government considered these key guiding principles when drafting this legislation. Appropriate stakeholder consultation would have ensured that these principles were considered. The next section that's concerning to me is subsection 5.2, which fetters regulatory discretion in decision-making by requiring regulators to license any applicant who is registered, licensed, and in good standing in any jurisdiction that government prescribes by regulation, without requiring any final authorization by that regulatory body. Subsection 5.2 doesn't define good standing. In the regulatory world, good standing is a term of art with a different specialized meaning depending on the statute, the profession, and the jurisdiction. An applicant who is, for example, in good standing in Peru may not be considered to be in good standing in Nova Scotia, depending on their home jurisdiction's cultural competency requirements, language requirements, good character requirements, or professional liability insurance requirements. If left as is, this provision enables government, without final authorization of health regulatory bodies, to require that regulator to license an applicant from another jurisdiction who may have a criminal background, who may lack sufficient language proficiency, competence, and professional liability insurance. It requires that this regulator allow that individual to practice in Nova Scotia. This creates a dangerous environment for patients who will ultimately be receiving care from regulators who are registered under Section 5.2. If I receive care from a physician licensed to practice under Section 5.2 who's considered to be in good standing in Peru, but does not possess professional liability insurance in Nova Scotia, I'm not sufficiently protected if I'm harmed during the course of that care. Ultimately, the regulation of professional practice through the creation of a licensing system involves the creation of valuable rights and is directed towards vulnerable interests. No one is better qualified, to determine the registration and licensing requirements for health professionals in Nova Scotia than health professionals who are practicing in Nova Scotia, who are themselves subject to the rules established by their governing body. As a regulated professional, I understand that being licensed to practice in Nova Scotia is not a right, it's an incredible privilege. I understand that working as a licensed professional in the province requires me to be held to high standards, to maintain cultural competence, to carry professional liability insurance. I understand that the best way to protect the public is to listen to regulators who are subject matter experts, who understand the risks, who interact with registrants, who screen these folks who are looking to be licensed, and who have no agenda beyond the public interest and public protection. As a member of the public, I do not want the decisions about who may be able to treat me when I am at my most vulnerable to be left to an institution that is not required to act in the public interest and that is ultimately accountable to voters. When it comes to registration and licensing requirements, public protection requires that regulators not merely be consulted, but have final authorization and discretion to determine which health professionals can practice ethically, competently, and safely in Nova Scotia. Thank you for your time.
Thank you. Okay, so we'll pass it over to members. We have MLA Jessam.
Thank you, Mr. Chair, and Ms. Langer, thanks for your time and presence here today. It's our understanding, and I don't claim to be too intimately familiar with the legislation at this point, the bill at this point. We're still working our way through the process, but it's our understanding that this would apply to Canadian jurisdictions rather than international ones. Is there an element of this bill that I guess opens it up for a more broad or a more inclusive opportunity to bring in, as you've referenced Peru as an example, but I just want to clarify where that element of the bill exists, if we've been misunderstood.
And I apologize.
Sorry. I'll recognize you, and then your mic will come on, and we'll go from there. So, Ms. Langer.
Yes, I apologize. I don't have the bill in front of me right now, but from my read of subsection 5.2, it prescribes any jurisdiction. So it does not limit this to Canadian jurisdictions. It's any jurisdiction prescribed by the regulations. So that's the nature of my concern.
Thank you. MLA LeBlanc.
Thanks very much for being here. Just a quick question. Do you see, given that we are trying to speed up a process of regulating health professionals so that we can address some of the concerns of what's going on in the system, do you see any place in the bill that could be tweaked or amended so that that would give the regulators, the final say? Or do you, as a lawyer, have you looked at it sort of clause by clause to see where it could be improved or fixed?
Certainly. So one of the big improvements that I would recommend. Sorry.
No, it's okay. Ms. Langer.
Thank you. Certainly one of the improvements that I would recommend is to require authorization from the affected health professions regulators before prescribing jurisdictions by regulation. There's currently no requirement, so that would be my suggestion. To require authorization of affected regulatory bodies prior to making any regulations under subsection 5.2.
I'll ask the members, are there any other questions for Ms. Langer? MLA Jessam.
How do I say this? If this legislation is to pass without that, at least my perception, duty to consult with these regulated professionals, does it become is there an opening for it to be challenged in court as potentially not legitimate?
Ms. Langer.
Certainly, anybody is welcome to challenge any piece of legislation that they feel is not legitimate. That answers your question.
Follow up. MLA Jessam.
Yeah, I guess like in establishing legal regulators, is there something specific that gives that establishes a specific requirement to consult with stakeholders that could be observed as like that piece of the required process was overlooked and not done, so it would create an opening for a legal challenge?
Ms. Langer.
Yes. So I think I understand your question. So are you asking whether the bill as written would open up the possibility of a legal challenge on the basis that it does not require authorization from regulatory bodies? As I said before, you know, any piece of legislation is up for challenge. I'm speaking today in terms of regulatory best practices. So, you know, it is best practice to consult these regulatory bodies, and the very fact that legislature has delegated the authority through statute to each of these regulatory bodies indicates the importance of that consultation.
Time is up. Time has elapsed for questions from members. I'd like to thank Ms. Langer for your presentation.
Thank you, Mr. Chair.
Have a great day. So I will ask Ryan Baxter to
Yeah, hers, yes. Yeah, no, I got it. You got it, yeah.
Good morning. Thank you for coming in this morning and providing us with a presentation on Bill 256, Patient Access to Care Act. So I'd like to start off by saying if you could introduce yourself and your guest, and you'll have 10 minutes to present, 5 minutes of questioning. I'll advise you when you have 1 minute left in your presentation, as well as questions. I'll just nod my head. So I'll ask you to begin. Thank you.
Thank you, Mr. Chair. My name is Ryan Baxter. You can refer to me as Mr. Baxter or Ryan. I am joined this morning by Jennifer Hemion, who is the Executive Director of the Nova Scotia Regulated Health Professions Network. Ms. Hemion will be speaking later today on her own behalf, but she is joining me as a guest for the duration of my submission here this morning. I'm a partner at the law firm of McInnes Cooper, and my law practice is almost exclusively focused on health law and the regulation of professions here in Nova Scotia. In terms of my legal work, I do represent the network, but I'll be speaking on my own behalf today. I have distributed my written remarks that I'll be making this morning to the committee. In addition, we've also circulated a written document that was provided to the Department of Health and Wellness, providing the network's feedback, detailed feedback with respect to some of its concerns regarding Bill 256. I won't be speaking to all of those concerns just out of the interests of time, but I will be highlighting a few of the issues that we've identified. First and foremost, this legislation represents a unique opportunity to improve Nova Scotians' access to healthcare services by reducing barriers for registration and licensing for professionals that are licensed in other jurisdictions to relocate to our province. Further, this proposed legislation contains mechanisms that we're hopeful will allow regulators to expand their scopes of practice in a more efficient manner that can be done today. We see mechanisms in this legislation that will allow regulators to amend their scopes of practice more efficiently, more timely, and in a more cost-effective manner. These are worthy aims. The network supports the intent of the legislation as drafted and welcomes this legislation. However, there are a few concerns that we have with the drafting that we think can be easily amended and addressed to reduce any potential risk to the public. It is unfortunate that neither the network nor professional health regulators in Nova Scotia were consulted regarding the content of Bill 256. Now, to be clear, regulators appreciate that advanced consultation is not always possible. However, regulators' expertise lies in many of the areas that Bill 256 canvasses. Regulators in Nova Scotia, they're the ones on the front line that have first-hand experience, and they have valuable suggestions to improve the draft language of this act, to improve its effectiveness, while still preserving the public interest mandate. Introducing this legislation in the absence of consultation potentially erodes trust between the government and Nova Scotia's health regulators, who are ultimately responsible for safeguarding Nova Scotians in the delivery of healthcare services. Two issues that I would like to address specifically are the requirement, this bill's requirement, to waive all registration and licensing requirements for an applicant who is already registered in good standing in any other jurisdiction prescribed by the regulations. So it's this concept of a mandatory waiver for good standing that I'd like to speak about. I'll also address the concept of an expanded scope of practice, which again, the regulators are supportive of. It's just the mechanism by which the scopes of practice can be expanded that we would wish to address. So starting with the waiver of registration and licensing requirements, certainly the intent to reduce barriers for competent and ethical professionals to move and practice to Nova Scotia is embraced. The regulators see it day in, day out. There's a pronounced and immediate need for more healthcare professionals in this province. But the goal simply can't be more bodies at any cost. At all times, Nova Scotians are entitled to receive care from competent and ethical professionals. But as currently drafted, Bill 256 will mandate regulators to fully license professionals in good standing from prescribed jurisdictions, even if those professionals have been convicted of criminal offenses, even if they are uninsured to provide health care services. That's an unacceptable risk to the public. That's an unacceptable risk to Nova Scotians. Regulators will be forced to license these applicants even if they're not competent to provide health care services, if they're incapacitated, if they have no knowledge of local Nova Scotia healthcare practices, if they are unable to communicate proficiently to their patients in either French or English, and even if they lack good character. The bill will also require regulators to license applicants without the ability to impose any conditions or restrictions that are commonly placed on applicants' licenses that are designed to ensure public safety. The regulators that I work with are certain that this is not government's intent, that it's not the government's intent to needlessly expose Nova Scotians to such unnecessary risk in receiving health care. Unquestionably, Nova Scotians deserve increased access to care, full stop. However, and surely we must ensure that that care and that access is provided by competent professionals. inappropriate and contrary to public safety to require regulators to automatically license professionals from other jurisdictions without first exercising some degree of due diligence to ensure that they are competent and they do have the character to provide care to our fellow citizens. To get to the root of the problem, the bill as drafted does not define good standing. As the committee has heard previously from Ms. Langor, good standing is not a term that is universally recognized or accepted, even in Nova Scotia, let alone outside the boundaries of Nova Scotia. So that is one of the significant problems, that it relies on whatever the definition of good standing is in the jurisdiction from which the applicant is moving from. Some jurisdictions don't have definitions of good standing. Some jurisdictions, the definition of good standing just means that you've paid your fees. So we are now opening up Nova Scotia to applicants who are registered in other Canadian jurisdictions without any screening whatsoever. And that can be changed with some pretty concise amendments that we're proposing to the legislation. The second issue that I wanted to address here with my remaining time is the concept of expanded scope of practice. The bill, as written, includes provisions that will enable the Governor and Council to make regulations that allow healthcare professions scopes of practice without the amendment is needed. The ability to expand these scopes of practice will help ensure that patients have access to safe, quality health care. For many regulators in Nova Scotia, the current process that they have to follow in order to amend their scopes of practice is very restrictive. It requires going through the full legislative process in amending an act. It's burdensome and resource intensive. However, while the regulators embrace this efficient means of expanding scopes of practice, there are some concerns. When read in conjunction with Section 7 of the Act, the definition of expanded scope of practice area suggests that an expanded scope of practice area for an individual can include services that are outside the scope of practice of the profession. So, thank you. So individuals are going to be allowed to practice outside of the scope of their profession as long as they believe they are competent to perform those services, which effectively means it's going to be up to an individual health professional to decide what their own competence is, even if that goes outside of the bounds of practice of the profession. Respectively, that would create significant risk to safety because we are now engaging in unregulated services. If a health practitioner is allowed to practice outside of the scope of the profession, there's no oversight. There's no ability for the regulator to ensure that those services are being provided according to standards of practice and ethical principles. The network's written submission contains some recommendations and language that is proposed to address these concerns. Overall, we fully support the intent of reducing barriers for competent, and that's the key, for competent healthcare professionals. And we're optimistic that this bill will allow scopes of practice to be expanded in a more timely way. Simply just asking for a few concerns to be addressed through amendment. Thank you very much.
All right, the time for the presentation has elapsed. We'll move it over to our members for questions. I'll have 5 minutes of questions, and we'll start with MLA Jessam.
Thank you, Mr. Chair. Appreciate your time, folks, this morning. We're still in the early stages of hearing from our general public and representatives from different organizations, and we appreciate hearing from you specifically as I guess an overarching voice for Nova Scotia's regulated healthcare professionals. the proposed suggestion, the amendments that we have before us today, in your opinion, are ways to improve it. Do your suggestions give the government a green light to move forward full stop? I think we're all on the same page with respect to the intent of this bill. I think that improved access is mission critical for us given the circumstances we're currently faced. So we want to, as at least members of the opposition, ensure that we're moving forward as smoothly as we can with respect to this effort. Do these amendments, with these amendments in place, would you be supportive of the bill on a go-forward basis? Through the chair.
Mr. Baxter.
Thank you, Mr. Jessom, for the question. Certainly, with the proposed revisions that the network has advanced, there would be full support for the legislation. We do support the legislation. We support the intent of the legislation. We think the way that it's been drafted will lead to some unintended consequences, which is, not unreasonable, but this is the opportunity to address those potential unintended consequences. Once the legislation has been passed, that opportunity will be missed. So we think it warrants just taking a moment to reflect on the wording, strengthen the bill where we can to ensure that these potential risks are mitigated against. That's all that we're kind of looking for, but we need the legislation. We support the legislation with the amendments proposed.
MLA Boudreau.
Thank you, Mr. Chair, and thank you for your presentation today. And certainly, very happy to kind of see kind of a summary or certainly a submission from the Health Network with identifying some of these. And certainly, I just want to kind of less of a question, but more of a comment. Just let you know that certainly the government will carefully consider the recommendations and the submission that you've put forward and that others put forward as well today. So I just want to thank you for coming and be very thoughtful with your presentation. So thank you.
Yeah. Any comment, Mr. Baxter? Okay. Yep. MLA Clark and then MLA LeBlanc.
Thank you, Mr. Chair. Thank you for your presentation this morning. I just wanted to clarify the last point you make here, the last issue you raised around regulation making authority to prescribe jurisdictions. I just don't see the recommendation there, so I'm just wondering if you could kind of explain what your view is in terms of how to make that process a bit smoother and fairer for, as you say, right now it reads as kind of a blanket ability to say, whether you're in Kazakhstan or Colombia or Alberta, you can kind of have this blanket exemption. So I understand you have issues with that, so maybe if you just kind of further explain what the issues might be. Thank you.
Mr. Baxter.
Thank you, Mr. Clark, for the question. And the concern really emanates with the lack of ultimate decision-making authority with the regulator. Certainly, the nurses and the physicians are currently embarking on good work in authorizing other jurisdictions and reducing outside of Canada. And we want to continue that work, but it's the regulator that is best suited to make that assessment as to whether or not an international jurisdiction meets our standards in this province. So we're looking for the regulator in consultation with government to have the final decision-making authority with respect to which jurisdictions are approved. It's significant work. It's labor-intensive work, as I'm sure you can imagine, that the nurses and the physicians have gone through, and we believe the regulators are best suited to make those decisions. Thank you.
MLA LeBlanc with 30 seconds.
Thank you. The regulators have been asking for an ability to increase scope of practice for a while, is my understanding. So can you just sort of walk us through that? Like, how long has that been being asked for, and therefore is it super surprising that the regulators wouldn't be included in the planning for this bill?
Mr. Baxter.
Thank you for the question, Ms. Lambois. So certainly it is something that a number of the regulators do not have the current ability to do without amending the legislation as a whole, opening up the act and going through that process, which is very burdensome. So the regulators certainly welcome the ability to expand their scopes of practice in a more efficient way. They just need more control over that process, and that's kind of what we've recommended in the submission, that because the regulators are the experts.
Time for questions has come to the end. I'd like to thank Mr. Baxter and Ms. Hemian for presenting to us today, and I would like to call our next witness to the front, Mark Williams. Good morning, Mr. Williams.
Good morning.
Thank you for coming this morning. If you could introduce yourself and any organization that you may represent, and how you'd like to be addressed during the questions from our members.
Sure. My name is Mark Williams. I'm representing the Nova Scotia College of Physiotherapists, and you can call me Mr. Williams or preferably Mark.
Okay, Mr. Williams, you can begin.
Great, thank you. Good morning. I'm here on behalf of the Nova Scotia College of Physiotherapists to provide feedback on Bill 256, the Patient Access to Care Act. Overall, we support the legislation and believe it can help us fulfill our mandate to serve the public interest. We do, however, have some recommendations to improve the legislation. We applaud the government for proposing measures that will enhance our regulatory agility. We are pleased that the proposed legislation will allow our scope of practice to be updated through regulations rather than statutes, and allow us to waive registration requirements when it is in the public interest to do so. We believe that these changes will help us respond to evolving healthcare needs in a timely and effective manner. It is important to note, however, that despite the Physiotherapy Act being in place for 25 years, physiotherapists are not currently being employed to their full potential scope of practice in Nova Scotia. Once physiotherapy scope of practice is optimized in the province, Bill 256 will allow for advancement and expansion of scope of practice to meet the competencies that are within the profession. We also support the proposal to limit companies' requests for doctors' sick notes. This measure just makes sense. It should, however, also include insurance companies that require physician referrals for physiotherapy services. Nova Scotians can directly access physiotherapy services without physician referral. Insurance companies requiring a physician's referral for these services amounts to an unnecessary barrier to healthcare, while also placing an unnecessary administrative burden on primary care physicians and general practitioners. This is not in the public interest. We are particularly pleased with Section 5.4 of the proposed legislation, which allows regulators to waive registration requirements when it is in the public interest. This provision will enable us to act quickly in times of need, such as during a pandemic. We do not have any concerns regarding sections 5.1 and 5.3, as we are already meeting those requirements. We also have no concerns regarding limiting the application fees. However, would prefer assurances of reimbursement being included in the bill to ensure that this does not become a cost hoisted upon current registrants and ultimately just being borne by exactly the folks that the provision is intended to appeal to. We also would like to reiterate the network suggestions that you heard Mr. Baxter give related to expanding scope of practice and use of the term good standing. We no longer use the term good standing with our national counterparts, but instead rely on specific regulatory history information consistent with the recommendations in the network's presentation and submission. Similarly, we support the suggestions related to Section 7 and 8 that pertain to expanded scope of practice. As regulators, legislative language is probably our most important tool, and the suggestions posed by the network will serve to hone and sharpen that tool. If you make no other amendments to the Act, please address these two. In conclusion, we believe that Bill 256 has the potential to improve the regulatory framework for health professions in Nova Scotia. We support the proposed changes to increase the nimbleness of a regulatory system, limit the need for doctors' sick notes, and allow us to waive regulatory requirements in the public interest. However, we recommend that the legislation go further by limiting insurers' requests for unnecessary physician referrals to physiotherapy services, and be amended to tighten up the language related to expanded scope of practice and good standing. Thank you for your time, and we look forward to continuing our collaboration with the government to improve the healthcare system in Nova Scotia, and I'm happy to answer any questions you have.
Thank you, Mr. Williams. I am going to ask the members for any questions. MLA Adams.
Thank you. I can't pass up the opportunity as a fellow physiotherapist who's still licensed with the College of Physiotherapy. Just wondering if you could tell us a few of the ways that you think physiotherapists could expand their scope of practice in Nova Scotia.
Mr. Williams.
Thank you. So in other jurisdictions, physiotherapists work in the emergency department. They can triage musculoskeletal and other related injuries or illnesses. If there's something that comes up that requires a physician, physiotherapists are trained to address that, and they're doing it all the time already in community practice. So there's very little risk involved, and it adds another member of the team with expertise in those areas. There's also other aspects that can be done within the emergency department that are very simple, straightforward. I recently ruptured my Achilles tendon. There was not a physiotherapist to even have a crutches for me to learn on if I was not already able to do that myself. So that would be one simple, straightforward one that would be easy.
Is there any other questions from our members? Seeing none, I'd like to thank Mr. Williams for your time and your presentation today.
Great, thank you.
Thank
for
you.
the opportunity.
I'd now like to call on Stacy Bryan. Thank you, Stacy, for coming into law amendments to present to our members and provide some feedback on Bill 256, Patient Access to Care Act. I will ask you to introduce yourself, any organization that you'd represent, and how you'd like to be addressed during questions.
So my name is Stacy Bryan, and I'm the registrar for the College of Dental Hygienists of Nova Scotia, or the CDHNS. And you can refer to me as Ms. Bryan or Stacy. And I thank you for the opportunity to speak to Bill 256 today. The CDHNS is the professional regulator of the dental hygiene profession in Nova Scotia, and we were established pursuant to the Dental Hygienists Act on May 15th, 2009. Our legislated responsibility is to serve and protect the public interest in the practice of dental hygiene and to ensure that Nova Scotians receive safe, effective care from competent and ethical dental hygienists. And it is from that lens that I make these comments to you today. The CDHNS also supports the intent of this bill, which is to increase access to care in Nova Scotia. We welcome the introduction of a bill that, if passed, will allow regulators to work collaboratively with the government and other stakeholders to explore other mechanisms to improve access to care. There are four main issues with Bill 256 that the CDHNS wishes to address, and these are scope of practice, the processing of completed applications, the requirement to waive all registration and licensing requirements for applicants who are registered or licensed in good standing in any jurisdiction prescribed by the regulations, and prescribed international jurisdictions for the purpose of registration and licensing. So turning first to scope of practice, the CDHNS supports the opportunity to make better use of the workforce, and we're eager to be part of the solution. It is well known that oral health impacts overall health, and dental hygienists are passionate champions of achieving oral health and overall health for Nova Scotians. There has been discussion already about optimization of the current scope of practice, as well as ensuring there is enabling legislation, as intended with this bill, to allow a profession's scope of practice to evolve over time. Firstly, the current scope of practice for Nova Scotia dental hygienists is not being optimized here in Nova Scotia. In October 2014, a CDHNS white paper entitled "Prevent More to Treat Less" was published. In it, we outlined the oral health issues in Nova Scotia, such as oral health inequities and the impacts and costs of oral diseases. We also offered solutions, including 13 recommendations of how dental hygienists could be better utilized within the healthcare system, such as investing in workforce innovations that optimize dental hygiene scope of practice in non-dental community-based settings like long-term care, daycares, and collaborative care centers. 9 years later, these oral health issues remain, and the majority of the recommendations have yet to be implemented in Nova Scotia. The CDHNS is also open to expanding the scope of practice for health professions, including dental hygiene, as professions change and grow. We appreciate that this new bill will allow the government, in collaboration with the regulator, to ensure that happens in a timely manner. The network submission regarding Bill 256, which Ryan Baxter provided to you today, proposes revisions to some of the wording of this bill around scope of practice. And these proposed revisions are intended to ensure public safety. And I'd like to briefly underscore a few of these points now from the CDHNS's viewpoint. It is critical that the Governor and Council engage in meaningful consultation prior to the enactment of any regulations that expand the scope of practice for any of the health professions. Ultimately, the regulators are the experts with regard to their respective professions. We are hopeful that government will appreciate and rely on this expertise when looking at expanding scope of practice. The CDHNS's interest in overseeing any changes to the dental hygiene scope of practice is embedded in its public interest mandate. We are committed to ensuring that any evolution to the dental hygiene scope of practice maintains the current level of safe and competent care that Nova Scotia expects of registered dental hygienists. Any expansion of a profession's scope of practice must include the ability for the applicable regulator to prescribe the requirements for a registrant to perform the new scope, such as qualifications, experience, and examinations. And turning to completed applications, in 2022, the average time that interprovincial applicants were issued a practicing license by the CDHNS following receipt of a complete application was 5 business days, which is the timeline outlined in this proposed bill. And while we support this timing inclusion, it is critical that Bill 256 includes a definition for complete application to ensure that both the applicant and the regulatory body have the same expectations. Currently, for the CDHNS, included our definition of complete application, which means that an applicant has submitted the required fees and all information or documentation necessary for the regulator to render a decision. So turning to mandatory waiving of registration and licensing requirements. Overall, the CDHNS concurs with the intent to reduce barriers to registration and licensing for competent health professionals who are fully licensed in other Canadian jurisdictions. However, we are of the view that the current wording of sections 5.1 and 5.2 of this bill will result in unintended consequences that have the potential to jeopardize public safety. Section 5.2 requires a regulator to waive all requirements for registration, licensing, or renewal for any applicant who's registered or licensed in good standing in any jurisdiction prescribed by the regulations. However, as several people have already mentioned, Bill 256 does not define good standing, and this term is not consistently applied across professions or jurisdictions. Pursuant to the current wording of this bill, regulators must rely on the meaning of good standing, if any, in the applicant's originating jurisdiction. The way good standing is used in Bill 256 may result in regulators being required to license applicants that are incompetent, incapacitated, lack character, or have engaged in misconduct. And this is not consistent with a regulator's duty to ensure that Nova Scotians are protected in the delivery of healthcare services. This section also removes a regulator's ability to assess whether any applicant has a disciplinary history in another jurisdiction and to address any conditions or restrictions on the applicant's license put in place by that jurisdiction. As a regulator operating in the best interest of the public, It is critical that we are able to look into an individual's character, competence, and capacity, and to implement conditions or restrictions that support the safe provision of care for Nova Scotians. And further, this section would even require regulators to license applicants that do not carry professional liability insurance. Currently, all dental hygienists practicing in Nova Scotia must carry insurance in order to ensure that any client injured while receiving care is protected. The CDHNS is certain that the government is not intending to permit uninsured healthcare professionals to practice in this province. However, that's what the current wording of Bill 256 would allow. The CDHNS recommends that subsections 5.1 and 5.2 be deleted and replaced with the text that Ryan Baxter outlined in his submission earlier today and provided to you in his submission. And it's also included in the hard copy of my presentation. And lastly, prescribed jurisdictions. The CDHNS appreciates that the intent of subsection 5.2 of this bill, in its reference to any jurisdiction prescribed by the regulations, is to further open Nova Scotia to out-of-province health professionals, those from other Canadian jurisdictions or from outside of Canada. And we concur that recruitment and licensure of out-of-province health professionals will assist in increasing access to health care in Nova Scotia. However, determining whether an international jurisdiction maintains similar education, entry to practice competencies or scope, etc., is a process that needs to be more clearly defined, either in the Act or its accompanying regulations. It may be that a prescribed jurisdiction or country may meet the equivalency requirements of one profession but not another. And it is our belief that a jurisdiction equivalency should be determined by profession rather than by implementing a blanket requirement for a specific country or jurisdiction. So I thank you for this opportunity to speak and open to any questions that you may have.
Thank you, Ms. Bryan. I will now pass it to our members for questions, starting with MLA Jessom.
Thank you for your time here this morning through the chair. We've heard on a couple of different occasions some variation of labor intensive has been used to describe the process to change scope of practice. And I'm wondering if you could give the committee an idea of how long something like that would take without the legislative requirements to go back to the House and change things in that space, because it sounds like maybe there's an opportunity to remove the legislative requirement but still maintain the ability for an individual regulated profession to make that call on their own terms, having done the due diligence required to be confident about making that decision.
Ms. Bryan.
Thank you. So if you're referring to our current framework that we have versus what is the potential of, or the intent of this bill, currently we actually submitted over 3 years ago some requests for changes to our regulations because we thought it would be a little faster than trying to revise our act, and we are still awaiting those changes. And some of those actually look to some of the changes in evolution of scope of practice. So that process has been taking a long time. If, in terms of the new act and this new potential, that I think that if the way that it's worded and the revisions that are provided for in the recommendations, I think that would then allow you to government and the regulators to be more flexible and nimble in implementing those as things change much more quickly. We've certainly seen during the pandemic that we have needed to be more flexible and nimble as we look at how we look to make the changes. So I think that this new potential with those revisions would allow that opportunity.
Thank you. Are there any other questions from our members? Seeing none, I'd like to thank you, Ms. Bryan.
Thank you very much.
Okay, I will now call our next witnesses, Dr. Gus Grant and Dr. Carrie McAdoo. Good morning, and thank you for coming this morning. What I'm going to do first, we have some new members sitting at the table, and I'd like for us to go around one more time to introduce the members, and then I'll bring it back to you to begin the presentation. All right. So we'll start with to our left. MLA Boudreau.
Thank you, Mr. Chair. Trevor Boudreau, MLA for Richmond.
John White, MLA for Clay Spain Dominion.
Good afternoon. Melissa Richard. I'm the MLA for Hants West.
Good afternoon. I'm Barbara Adams, the MLA for Eastern Passage.
Hello, Susan LeBlanc, MLA for Dartmouth North.
Lisa Lachance, MLA for Halifax, Citadel, Sable Island.
Hello, Kelly Regan, MLA for Bedford Basin.
Good afternoon. Rafa Di Costanzo, MLA for Clayton Park West.
Thank you to the members. I will now pass it to Dr. Grant for your opening remarks.
Thank you. It's a pleasure being here. I'm Dr. Gus Grant. I'm joined by Dr. Carrie McAdoo. I'm the Registrar of the College of Physicians, Surgeons of Nova Scotia. Dr. McAdoo is the Deputy Registrar. These submissions will be on behalf of the college, but the college did endorse the submissions of Ryan Baxter made previously on behalf of the network. The college's mission is public safety. It's through the lens of public safety that we do our work of licensing, setting the standards for the profession, investigating complaints, and generally regulating what is over 3,300 physicians and resident physicians in the province. All of us are united to public safety, everyone in this room, and the government's correct to focus on access to care as our most pressing issue. And the college wants to be part of the solution to help deliver on these goals. Dr. McAdoo and I are both long-standing family physicians, and we worry for those without primary care. Lack of access to primary care in particular is not safe. The government, the public, everyone in this room can see that. As we all seek to expand access to care, the college can help ensure that when care is accessed, it's safe care. There's much in Bill 265 which already aligns with the work we do. We already turn completed license applications around quickly, always in less than 5 days. We license physicians readily from other provinces. Access to care is more important than application fees, which are waived by this act. And as registrars, Dr. McAdoo and I, through the Medical Act, have broad authority to exercise discretion to waive license requirements, discretion that we exercise regularly and have throughout the pandemic. As a regulator, we have concern about some of the language in the Act and how that language might affect the path forward. For the Act to achieve its goals safely, particularly if the Act stands unamended, robust and thoughtful regulations are needed. Let me offer a few examples. Some that you've already heard, so I'll skip through them, but to improve access to care, the Act seeks to bring expansion of scopes of practice into regulations, so as to ensure that all health professionals can work, and these are the quotes, to the full extent of their training. Bringing scope of practice under regulations is a very good idea, particularly for professions hamstrung by scopes defined by their Act that have now been outdated. We support and applaud this. Regulations can be changed more quickly than acts, and if collaboratively developed by government and the professions, can allow defined scopes of practice to keep pace with the evolution of healthcare. We applaud the idea here, which is to enable professionals to maximize their contributions, but the chosen language is to let professionals work to the full extent of their training. And those who work in healthcare would prefer a different language. We speak in the language of competence, of which training is just this one component. We include currency, experience, continuing professional development. Training is just one component of competence. As I say in my submissions, I was trained to deliver babies. I delivered my last baby 20 years ago. Dr. McAdoo's in the same boat. We're trained to deliver babies. I'm not competent to deliver babies today. It's a small example, but it's an example that I hope underscores the need for the voice of the professions to be in the room when regulations are developed. I think you've heard a litany of people talk about good standing, so I won't overemphasize the point. Again, mobility of professionals and physicians from elsewhere in Canada to get licensed here quickly, absolutely a good idea. It's already in place. Our concern is with the language of in good standing, which has been previously described, could refer to an organization as fees are up to date. We would prefer language that describe good standing, perhaps to say a physician independently licensed to practice without condition, restrictions, or undertakings. Good standing is vague, unclear language. Again, it's a small example, but I hope you see it as another example of why the professionals involved need to be in the room when regulations are developed, if the decision is not to alter the act. I'd like to spend a few minutes talking about physician mobility and the recognition of international medical graduates. The college fully supports mobility and any effort to welcome competent physicians to Nova Scotia. Most would think that there's but one type of medical license. There are many. And in addition to license types, many physicians have conditions, restrictions, undertakings in place on their license, which regulators put in place for the purpose of safety. That's one of the hardest parts of our job, to identify and define conditions and restrictions that will allow a physician to safely practice. When a physician changes provinces, these safeguards need to travel with the physician. I put it this way: the driver licensed to drive a passenger vehicle only in Ontario should not drive a big rig in Nova Scotia. I'd like to draw attention, or at least alert your focus to Section 8(1)D. And this is the section that confers to government the authority to identify international jurisdictions where Canadian license requirements could be waived. You may not know that we already do this. For family physicians certified in Australia, the UK, Ireland, the USA, they're licensed as of right here. Similarly, all physicians certified in the US are licensed as of right in Nova Scotia, and we're the only province in the country to do this. We arrived at this after satisfying ourselves that practice, training, certification in those jurisdictions was acceptable to us. We're keen to explore other jurisdictions that would merit the same treatment. And I would say in our experience, it's a far more complex undertaking than you might think. I can say this, that Nova Scotia's doorway is wider and pathway to long-term licensure is shorter than any other province in the country. And to go further, I would submit safeguards are needed, and that the medical profession at all levels, including medical educators, medical practitioners, and regulators, need to be in the room when those decisions are made. It's tempting to think biology is biology. And if biology is biology, then medicine is medicine. But medicine is a lot more than biology. Medical training and practice vary greatly around the world, particularly in areas where culture, law, and medicine overlap. And I can speak from direct experience as the registrar that physicians arriving to Nova Scotia from other parts of the world often come with different training and approaches to important issues like contraception, informed consent, human rights, mental health, abortion, opioid prescribing, and medical assistance in dying. For such reasons, these physicians, when arriving in Canada, need oversight and supervision. And to set arriving physicians up for success in practice, we need to focus on welcoming, orientation, supervision, support, and mentorship. For this reason, the college recently developed the Welcome Collaborative, and we enjoyed, very grateful for government funding in that regard, which is an intense and longitudinal orientation to welcome international physicians. Next month, 19 physicians, mostly from Nigeria, by the way, will spend intense time with the college building relationships and also getting familiarized with Nova Scotia practice. It's hard to come to a place, even one as welcoming in Nova Scotia, where you look different and sound different than most of your patients. You have my submissions. The proposal I request is as follows. We want to bring this bill comes with good intentions and good ideas, but to achieve them safely, we would propose the following: that this committee add language to the bill declaring that the bill can only be effective when the enforcing regulations are developed, and ensuring that the regulations, when developed, shall be developed with the presence of the professions in the room, and thirdly, that the bill and regulations be followed as a whole. Indulge me for a second as I squeeze the last few seconds out of my allotted time. Through the lens of safety and through the knowledge of healthcare, the college has long collaborated and supported thoughtful expansion of scopes of practice for all allied health professionals. One need only look at the expanding role and contributions being made by paramedics, nurse practitioners, licensed practical nurses, the expanding role of pharmacists, paramedic scopes of practice over the last decade, to recognize that this is something that's in constant evolution, hence the support for the movement into regulations, but B, the need for the colleges and the professions to be involved.
Order. Time has elapsed for presentation. I will now pass it along to our members for questions, starting with MLA Di Costanzo.
Thank you for the presentation. And I do have a lot of questions from what you spoke, but I do have a burning question that I wanted to ask. I'm all for expanding scopes and having as much of the, the simpler things that pharmacists can or nurses can do, pharmacists can do, and others taken away from the family doctor so he can focus on the more chronic diseases and other things. However, what I'm hearing now, what is happening is even patients who have family doctors are going to all these options, whether it's virtual care, pharmacists. However, if you have a family doctor, all your information is now being faxed back to the doctor. The doctor is responsible to hire somebody to enter all this data, plus he has to read to make sure everything is accurate and he's content with it. He or she, I'm sorry. And no pay for any of that. And they are inundated with that. How do you solve this issue now?
I think you're asking me to answer the question.
Oh, sorry. Dr. Grant.
How do you help those doctors?
Well, I'll harken back to when I did practice. We were all frustrated as family physicians having downloaded. We felt there was a stream of downloaded administrative responsibilities to us, and I think it's important to focus on that right now. And with the variety of sources of care now, as patients seek whatever care they can, right? There is a deluge of paperwork to the family doc. I think we have to look at it, and again, this is somewhat out of my swim lane, but I think we have to look at this sequentially and try and figure out a way to maximize time spent by family docs doing care that they alone can provide. It's an unsatisfactory answer to a really unsatisfactory situation, but I did want to echo to my colleagues in family medicine that's a long-standing issue.
MLA Regan.
Thank
Thank you. So when you said that the bill can only be effective when the enforcing regulations are developed, I'm assuming what you mean is the bill can only come into effect, right? Just to clarify the language there, because of the different meanings of the word effect and effective.
Dr. Grant?
I'm sorry.
No, it's okay.
Our concern that there is that the devil's in the details. However well-intentioned this act is, without thoughtful and developed regulations, then I don't know how the good intentions of this bill can be realized. So our ask is that the professions involved be included in the regulation process, and that the bill only be effective when the regulations have been reached.
MLA LeBlanc.
Dr. Grant, at the beginning of your presentation, you said you endorsed the presentation of the lawyer that represents the network. But then in your presentation, you're proposing you're not proposing specific amendments. You're proposing sort of these overarching sort of caveats. And I'm wondering, given that you do support the submission, so do you want to see those amendments in this bill before it's passed at all? Let alone if regulators are not included in the regulations?
Dr. Grant?
I'll learn eventually. Maybe. The thrust of our submissions is this. This bill depends on regulations to be effective. And for regulations to be safe and effective, the voice of the professions need to be engaged throughout the development of the regulations. If the bill, I think the amendments proposed by the network are reasonable. I think my sense, however, is that if the bill gets passed unamended, which I understand is more common than not in the political process, then the voice of the professions, all professions, need to be engaged. This is complex. This has been my life's work. This is complex stuff, and I hope the professions will be heard and collaborated with.
MLA Regan.
So from your presentation, and again, I just stepped in here, so I didn't hear previous speakers. I am assuming that the college was not consulted when this bill was being drafted on the language. Is that correct?
Dr. Grant.
I guess I won't learn. We were not, and the minister acknowledged that.
Order. The time for questions has elapsed. I want to thank Dr. Grant and Dr. McAdoo for presenting with us today, and we're going to take a 5-minute break, and we'll conclude here at 12:17.
All right, folks, we have 1 minute, and then we'll be going back in. All right, thank you, everyone. We're going to resume now. I would very quickly, I don't know if everyone who's in the room were in the room when the initial rules were read, so I do want to point out one rule and ask if possible people could assist in this one. Usually we're over, of course, in Province House in the Red Room, and we have quite a large room. Unfortunately, because of construction, we're here in one gov, and so limited space here. I would ask speakers, if you have already spoke or once you're finished presenting, if you could leave and make room for somebody else to come in. I do know that they have chairs set up over at Province House if anyone would like to go over there and continue to listen, but we want to ensure that we have space for all our speakers as we move forward. Carrying on still with a time frame of 10 minutes to present and 5 minutes for follow-up questions. Moving on now to speaker number 6, which is Julie Avery. And I'd ask Ms. Avery to come forward. Thank you. Just before you start, if you would identify your name for the record, as well as any organizations you may be here representing, or if you're just here on your own. And if you could let committee members know how to address you, that would be good as well. So if you want to do that, and then I'll start you out, and we'll turn it over to Ms. Avery.
Yes, I'm Julie Avery. I'm the Executive Director and Registrar of the Nova Scotia College of Medical Imaging and Radiation Therapists. That's who I'm representing today. You can refer to me as Julie or Miss Avery.
Whenever you're ready.
Okay. We are the regulator of 5 professional groups in Nova Scotia, just in case you're unaware. They include diagnostic medical sonographers, magnetic resonance imaging technologists, nuclear medicine technologists, radiation therapists, and radiological technologists. The purpose of Bill 256 is to improve patient access to care by further opening the province to out-of-province health professionals and enabling expanded areas of practice. These objectives are shared by our college. Our college supports improving patient access to care in Nova Scotia while also promoting public safety. We are concerned with the use of the word training in the purpose section of Bill 256 and strongly recommend that it be changed to individual scope of practice for the reasons as set out in the network submission, principally that training does not equate to competence. A few examples of actions our college has taken that demonstrate this shared goal of improving patient access to care include: we quickly developed processes and policies to support emergency licensing of applicants to support HR needs of the hospitals during COVID-19. We advocated for the passage of our regulations that advanced the proclamation of the Medical Imaging and Radiation Therapy Professionals Act, which established the college. This legislation supported us being a more responsive regulator. We are now able to license new graduates and international applicants who are registered to write the National Entry to Practice exams, allowing technologists and therapists to enter the workforce earlier and supporting international applicants in gaining Canadian experience, which helps them in preparing to challenge the national exams. We have also recently developed exam prep programs and competency-based practice exams that mirror the National Competency Blueprint to further aid international applicants in successfully challenging the national exam. Last year, we added broader data collection points to support provincial HR planning needs to better determine on-tap capacity in the system. Currently, we are working with the Nova Scotia College of Medical Laboratory Technologists to support the regulation of combined X-ray lab technologists in the province. The intent is to assist in addressing access issues to these services, especially in rural Nova Scotia, by creating increased options for safe care delivery. Nationally, we are collaborating on a full review of assessment processes for international applicants, looking at both necessity of a requirement and what is accepted as evidence for meeting a requirement. As the Executive Director of the Imaging and Therapy College, we are a signatory to the Nova Scotia Regulated Health Professionals submission to the Department of Health and Wellness regarding Bill 256, which speaks more specifically to the broad support of regulators to the intent of this legislation. Given this, I would like to spend the rest of my time today highlighting two sections of Bill 256 that our college has specific comments that we would like to share. The first area is Section 5.2, which states that regulators must waive any requirement for registration, licensing, or renewals of registration or licensing for any applicant who is registered or licensed and in good standing in any jurisdiction prescribed by the regulations. Our college supports removal of unnecessary barriers to licensing for competent applicants that are fully licensed in other jurisdictions, but does have concerns related to using the undefined term good standing as the standard, without the bill giving a clear definition of what constitutes good standing. Good standing for some regulators simply means fees have been paid. This would eliminate our ability to screen for concerns such as current complaints, criminal records, or address current conditions on a license. As written, this provision of Bill 256 could also result in registrants practicing in Nova Scotia without required liability insurance or adequate proficiency in English. By adding the suggested edits proposed by the network, the public can be confident that individuals practicing in Nova Scotia meet good character standards without adding unnecessary risks or burdens. The second area I wish to discuss is Section 8, which deals with the concept of expanded scope of practice area. This is something our college has wanted incorporated into healthcare legislation. Healthcare practice is not static and at times can take large leaps in a short period of time. Our college is made up of 5 professional groups that deliver direct patient care. They do this with the assistance of cutting-edge technology. When the technology we rely on takes a large leap forward, the care processes and standards can change overnight, which impacts scopes of practice. As regulators, we do not get to pick and choose what portion of our legislation we abide by, and are often hemmed in by our own legislation. For this reason, we welcome legislation that is more nimble. One clinical example I can give to you to illustrate this is the use of CT imaging in clinical exams. Traditionally, this was a radiography procedure, thus under the scope of practice of radiological technologists. Approximately 20 years ago, advances saw CT be merged with other systems such as positron emission tomography and SPECT imaging. These exams were in the scope of practice of nuclear medicine technologists. SPECT CT and PET CT quickly became the clinical standard. This created a regulatory issue as neither radiological technologists nor nuclear medicine technologists had a scope of practice that encompassed the new clinical reality. It took 10 years to have legislation, took 10 years to have legislation that clearly expanded nuclear medicine scope of practice to include CT in Nova Scotia. This is not responsive or in the public interest. Having legislation that would allow for situations such as this to be addressed in a timely manner is supported. While we need legislation to be more responsive, patient safety must also be at the forefront when scopes are expanded, and the body best positioned to assess if a specific practitioner or profession as a whole has the required competency is the regulator of that profession. I encourage that wording in Bill 256 be amended to ensure that it is regulators authorizing registrants to practice in expanded scope of practice areas and regulators who prescribe requirements for practice in expanded scopes of practice areas, including requirements for qualifications, experience, or examination. For the 5 professional groups regulated by our college, I expect the scope of practice lines to continue to move and blur. We have also received requests to allow registrants of one discipline to practice aspects of another discipline under specific conditions. As a nimble regulator, where it is in the public interest to expand scope, we would like to be able to act on these requests to set the required criteria to enable it. A full outline of specific concerns and suggested edits as proposed by the College of Nursing and the network are supported by this college and included in Appendix A of my submission. Thank you.
Thank you very much for your comments. I will now go to members of the committee to see if there are any questions. No questions. Thank you very much for your time today.
Thank you.
Moving on to our next presenter, Dr. Doug Mackey, sorry. I've become known for butchering everyone's name, so I apologize ahead of time. Dr. Mackey, if I'm not quite sure where the pages went. I see you do have a handout. Maybe if you pass it to MLA Ritzy, he can, there. Thank you. So thank you very much for coming today. I would ask if you could identify your name, if you're here representing any particular organization, and how you would like to be referred to by committee members. Once you're done that, I'll start the clock, and you have 10 minutes to present with 5 minutes to follow up.
Good afternoon. So I'm Dr. Doug Mackey, and I'm the Registrar of the Provincial Dental Board of Nova Scotia, and you can call me Doug. On behalf of the Provincial Dental Board, I thank you for the opportunity and the privilege to address you today. I'd also like to commend government for turning its attention to healthcare in such a focused way, and to thank members of the opposition for their support of these initiatives. Specifically, I applaud you for the various initiatives around access to oral care or access to care. There are unquestionably several factors limiting access to oral health care for Nova Scotians. And the timing of this bill coincides nicely with other initiatives at the provincial and federal levels aimed at improving access to oral health care, particularly for marginalized groups. The mandate of the Provincial Dental Board aligns with that of other Nova Scotia health regulators, namely to protect the public interest and safety, in our case, specifically with the delivery of dental care. One of the critical ways we do this is by ensuring that we issue licenses only to individuals with the necessary knowledge, skills, and abilities to practice dentistry competently, safely, and ethically. I'm sure you would all agree that when a Nova Scotian is reclined in a dental chair, they have a right to know that the practitioners working on them are safe and competent to practice. With your indulgence, I would like to present an overview of one of the areas in which we fulfill this mandate of public protection, specifically as it pertains to the assessment of educational backgrounds of applicants from various jurisdictions. And then I will describe how Section 8(1)D of this bill, as presently written, will impact our ability to fulfill this important role. I would also like to express that the Provincial Dental Board is supportive of and aligns with the feedback provided earlier by Mr. Baxter on behalf of the Network of Regulated Health Professions. Across Canada, dental regulatory authorities rely heavily on qualified third parties to aid in determining competence of applicants. One such organization is the Commission on Dental Accreditation of Canada, which has a rigorous process for accrediting all oral health education programs. Coincidentally, the undergraduate and graduate programs at Dalhousie's Faculty of Dentistry are undergoing their accreditation survey site visit as we speak this week. I'm supposed to be there now. So all dental education programs are subject to site visits every 7 years, in which a team of accreditation surveyors descends on the school and performs a thorough, in-depth assessment of the educational content and processes after having reviewed extensive documentation provided by the programs. From my past experience, both as a part-time dental educator at Dalhousie and an accreditation surveyor elsewhere, I can report that dental schools take the accreditation process very seriously and work extremely hard to meet or exceed the minimum requirements to maintain accreditation. So as a dental regulator in Nova Scotia, when we receive a licensing application from a graduate of an accredited institution, we can have confidence in their educational background, which is one key factor in determining competence. We understand that health education varies widely around the world and in many ways, including entry qualification for programs, scope of subject matter, and teaching pedagogies and methodologies. Certainly, there are likely jurisdictions where the quality of dental education meets or exceeds that in Canada, and other areas where it may not. For example, there are dental schools in the world in which students graduate without ever having performed any dentistry on actual patients. So this contrasts with Canadian accredited schools in which students spend 2 full years treating patients daily under supervision. So obviously it's simply impossible for dental regulators to know what standards are upheld by every single non-Canadian dental education institution. For this reason, Canadian dental regulators and their partners have developed innovative approaches to assessing international applicants. At the end of the day, we want to license every qualified and competent practitioner who wishes to contribute to the delivery of oral health care in Nova Scotia. One of the ways we have opened pathways to licensure for graduates of dental schools outside Canada is through the development of mutual recognition agreements with other countries. To date, the Commission on Dental Accreditation of Canada has developed such agreements with the accreditation bodies in the US, Australia, New Zealand, and Ireland. So these accreditation bodies have done deep dives into each other's accreditation requirements and processes. The result is that dental education programs in these other countries are deemed accredited in Canada, and their graduates follow the same pathway to licensure in Nova Scotia as graduates of Canadian programs. Notably, this reciprocity is maintained through ongoing dialogue and evaluation of each other's accreditation standards and processes. The development of such agreements is not a one-and-done exercise. It requires experts in dental education and accreditation who are continually reassessing to ensure the standards are comparable in these jurisdictions. It is also worth noting that there are ongoing initiatives to develop mutual recognition agreements with other countries in the future. For graduates of dental training programs which are not accredited in Canada, so those outside Canada and the 4 other countries I mentioned, Canadian dental regulators rely on the National Dental Examining Board of Canada, which has a dedicated credential verification department with a team of experts in this field. Since 2011, the National Dental Examining Board has offered a series of 3 assessments, which gives dentists from non-accredited programs the opportunity to demonstrate equivalence to graduates of accredited programs with respect to knowledge, judgment, and the psychomotor skills necessary for the safe practice of dentistry. Once deemed equivalent, a graduate of a non-accredited dental school follows the same pathway to licensure as a Canadian graduate. And alternatively, these dentists can choose to do a gap training program at a Canadian faculty of dentistry. Another initiative earlier this year, the Canadian dental regulators engaged with the Association of Canadian Faculties of Dentistry to secure federal funding to explore the development of additional pathways to licensure, the goal being to further enable qualified individuals to obtain licensure while ensuring public protection and safety. These initiatives have been quite successful in facilitating entry into the profession for dentists trained outside Canada. Between 2010 and 2022, the number of newly licensed dentists in Canada trained in Canadian programs has been equivalent to the number trained internationally. In Nova Scotia since 2019, 25.5% of newly licensed dentists had received their primary dental training outside Canada. This makes it clear that as health regulators, we are not being protectionist gatekeepers, but rather are supporting measures to facilitate entry into the profession for qualified individuals without wavering on our commitment to public safety. What all these various pathways and initiatives outlined have in common is that they are necessarily complex and require people with expertise in areas of dentistry, dental education, credential verification, and accreditation who turn their focused attention to these matters on an ongoing basis. It is also worth noting, as Dr. Grant mentioned, some of the larger regulatory authorities in the room, such as medicine and nursing, have the capacity and expertise to fulfill some of these functions independently. However, smaller regulators like the Provincial Dental Board and many others here with me do not have the human resource capacity or expertise to perform the important tasks related to credential verification and assessment, which are essential for public safety. We require partnerships with third parties on a national scale who have the expertise and human resources needed. This brings me finally, and I thank you for your patience, to Section 8.1D of the proposed Act. This section will give the Governor and Council the power to make regulations to prescribe jurisdictions for the purpose of this Act. In simpler terms, government alone would have the unilateral ability to determine from which international jurisdictions applicants must be deemed equivalent to applicants trained in Canada. I was very pleased to hear Minister Thompson, in her address to the legislature last week, allude to the partnership and interdependence between government and Nova Scotia's health regulators. However, I respectfully note that Section 8.1D of the proposed Act does not acknowledge this important and necessary relationship, making no reference to the role of regulators in this matter. I would respectfully ask the committee to consider amending this section to enshrine the requirement of government to work with health regulators and their partners when prescribing jurisdictions for the purpose of this Act. In matters of Nova Scotians' health care, we count on government to work closely with experts in various fields. To do less could, in time, have serious unintended consequences and could negatively impact public protection. Once again, I thank you for the opportunity to be here today, and I thank you for the work you do on behalf of Nova Scotians. I'm happy to take questions.
Thank you very much for your presentation. You had 30 seconds left. That was well timed. I will go to members. I do know that we do have a couple, so I'll start with MLA Regan, please.
Thank you, Doug. Feels weird to say that, but Dr. Mackey. Yep. So when you talk about safety of the population, can you give us an idea of what kinds of things can happen if people are licensed to practice dentistry who may come from a different jurisdiction or do not have the appropriate training that we would expect here in Nova Scotia? What could be some of the, I think you referred to as serious unintended consequences. What could they be?
Right.
Back to the speaker, please.
Thank you, Mr. Chair. So right off the bat, before we even think about the technical skills, we look at issues like informed consent. So how is informed consent enshrined in the dental education and the dental culture of jurisdiction X? And is that comparable with what we expect in Nova Scotia? So if informed consent is not in place, right off the bat, that can lead to a cascade of negative consequences, which can be very serious.
Thank you. MLA Boudreau?
Thank you, Mr. Chair, and thank you, Dr. Mackey, for presenting today. And I'd said this earlier in kind of one of the former submissions. I'm not sure if you were here, but certainly I want to let people know that we are taking the submissions that are being presented and carefully considering them, both the government and the department. So I just wanted to make that comment and thank you for the work you put into this today. Thank you.
Thank you, MLA. MLA DeConstanza. Oh.
Zo. Without the N. You're adding an N and no problem. Good afternoon. Good afternoon, Mr. Mackey. I'm wondering if you can just give us an idea of, are we graduating enough dentists in Nova Scotia? And I see that you said 25% in 2019 they were they were educated outside of Nova Scotia. Are they all international? Are they from other provinces? What is the situation of the number of dentists that we need in this province, and how many are we graduating every year?
So firstly,
Speaker.
Oh, sorry.
Mr. Chair, sorry. So firstly, 25% were trained outside of Canada. And as to the question, are we licensing enough dentists? Are we educating or licensing? Both, yeah. So I don't know that there's any data or that there's been any really studies or analysis to really make that determination. Anecdotally, I'm not aware of there being an insufficient supply of dentists in Nova Scotia, although in pockets there could be, but there's no data to really support that at the moment.
Thank you very much. Any other questions? Thank you very much for your time today. Have a great rest of the day.
Thank you very much.
Moving on now to our next speaker. Alex Stratford. And once again, you have 10 minutes to present. Before you do that, if you could please identify yourself for the record, as well as if you're here representing any particular organizations and how you would like to be addressed by committee members. and then I'll start your time.
Great. My name is Alex Stratford. Pronouns he, him. You can refer to me as Alec. I'm here today on behalf of the Nova Scotia College of Social Workers. Ready? Great. So I come here as a representative of the college, and I'm speaking on behalf of the College of Social Workers today. I'm going to take a bit of a different approach than my fellow regulators have, much like social workers would. With process and direction, we do have major concerns with the process and direction that professional regulation is taking in Nova Scotia. My presentation today is an invitation for critical reflection and evaluation of how we are changing our health and social care systems, particularly in regards to safety and the care of the most vulnerable in our society. This does require an honest appraisal and clear understanding of how our systems have existed, and particularly the broader political context. So the Nova Scotia College of Social Workers does hold a unique position amongst the self-regulating health professions in Nova Scotia. As social workers interact with the most vulnerable and marginalized populations. In addition to our understanding of policies and regulations, social workers also have a deep understanding of the regulatory environment in which we and our clients operate, allowing the profession to be well positioned to provide meaningful input into provincial policy decisions that can improve outcomes for those we serve. With our commitment to promoting best practices, advocating for policies that lead to social justice, and upholding ethical standards within the profession, the NSCSW plays a crucial role in advancing a unique regulatory lens rooted in the values of profession. While our organization is not directly impacted by Bill 256, as regulators and observers to this process, we felt it was important to add our voice to this important piece of policy legislation. Now, to be clear, the college does not oppose what the bill intends to achieve. Nimbleness in regulation and a focus on access to health care are paramount to the public interest. Our organization, like many of my colleagues, have worked over the last 6 years to increase the number of registered social workers. Our efforts have included enabling telepractice for social workers registered in other jurisdictions, fast-tracked applications while maintaining public safety for additional screening checks, and we are currently updating our process for the approval of private practitioners to focus on right-touch regulation. In addition, we have continued to make massive efforts to not just address access, but equity in healthcare delivery, with a clear focus on implementing calls for anti-racist policy and justice in the delivery of social and healthcare. As you've heard today from many regulators across the healthcare sector, there is a shared priority for this work, and one that many of us have been working on for years. However, our college is deeply concerned about the enactment of any legislation that enables interference in the independent regulatory affairs of colleges, as independence from government is a key requirement for upholding and protecting the public interest, particularly the interests of the most vulnerable in our society. What is most troubling about the bill is the intent of the government through regulation to expand the scope of practice of an entire profession with only a duty to consult the regulators required. Consultation is of course not binding, and if it is not done meaningfully, it is ineffective. The recent experience and the lack of consultation on this bill provides no assurance to regulators that the expansion of a profession's scope will consider the concerns of regulators. There are other provisions in the bill that, if enacted, would create the context for unregulated practice, which is a major concern for the public safety. In order to do this and engage in this critical reflection, we also need to look at the history of regulation of the professions in Canada. It's an important part of how we reflect. When professional regulation was coming online in Canada, there was a focus on quality assurance and the protection of human rights. However, researchers have demonstrated that consecutive government worldviews have stressed the importance of free markets, deregulation, and privatization. Has become the dominant force in public policy making since the 1980s, and is influence can be seen in many aspects of modern life. Through this worldview, regulation is viewed as a barrier that stifles innovation and reduces competition and access. This trend can be felt in the modernization of health regulation, where governments are changing the definition of the public interest away from service quality and towards open competition and cost reduction. The NSCSW holds the view that this approach undermines important protection for workers, consumers, and the environment while leading to greater income inequality between the rich and the poor. The trust that members of the public place in health professionals is of paramount importance as it ensures trust and safety in services provided. However, there is a lack of growing trust in government-related services, which is a direct reflection of society's rising inequality. It is essential that we make efforts to address the issue if we are to effectively improve healthcare outcomes in Nova Scotia. Now, Nova Scotians have been crystal clear that healthcare reform cannot wait. Ensuring that everyone has access to quality healthcare is an admirable and commendable goal, one that our organization shares with this government and all Nova Scotians. However, our college is concerned that the goal of access is being politicized, both the problems and solutions, and again, that many of these problems and solutions can be solved through collaboration. Collaboration that is rooted in maintaining trust, quality service, and increasing access. The process chosen by the government to enact this bill sets a troubling tone, one that in our opinion was not necessary to resolving the collective challenges that we face. It has subjected independent regulatory bodies to increased politicization, and if not amended, it threatens the independence of regulatory bodies and subjects them to future partisan agendas that may not align with the public interest. I trust that all the members of the Law Amendments Committee will appropriately amend the bill so that it can achieve its goals, while at the same time maintaining the integrity and independence of regulatory bodies. It is our belief that in doing so, we will continue, it is our belief that if we do not do so, it will continue the trend that drives inequality and inequity, leading to declining outcomes in health and social care. At this point in our history, it is fundamental that we all work to strengthen democratic process, not weaken it. The current political climate continues to see a growing trend towards the retrenchment of democratic process, where the decision-making powers that impact the public interest are left to a few people, and too often is left to people who have political agendas that are not aligned with the public interest, particularly the interest of the most vulnerable and marginalized. Historically, when power has been entrenched in the hands of a few, marginalized and vulnerable populations bear the brunt and the negative consequences of that. Again, the rest of my submission here flows from what the network has said. I fully endorse what my colleagues have put forward in terms of this bill, but do caution the approach that was taken here and welcome critical reflection on the important role of regulation in our society.
Thank you very much, and we do have a few questions. Thank you. We'll go to MLA Regan, please.
Mr. Stratford, thank you for coming in today. Could you give us an example, a number of your the previous presenters have talked about public safety, and you have focused on really sort of equity and access. Could you give us an example of what happens if we get this wrong?
Yeah, I think that's a great question, and I'll speak to, although social work is not being impacted here, I'll talk.
I'm sorry, to the speaker, thank you.
All right, I've been watching all morning and didn't catch on. So I think this is a really important question. So there, as everyone knows, there is increasing pressure and increasing, again, just demand to be able to fill vacancies so that we can deliver health care. Let me talk about social work. Again, not being impacted here, but this is the potential that happens. So we have a lot of BSW educated graduates that work in the healthcare system, do great, incredible work. Again, a BSW educated social worker can provide general counseling, provide assessments, and help with some of that navigation in the system. What we're hearing about already is in places where there's a lack of psychologists or psychiatrists, that often those BSW educated social workers are being asked to fill those roles or those vacancies, take on some of those tasks because the vacancy is there. That does pose substantial safety issues. Now, our registrants are really good at recognizing, no, that's not within my scope, and they call and say, what do I do here? So the reality is that if this bill was enabled without amendments, the government could say, no, you are now able to provide clinical mental health assessments because basically we don't have anyone else to do it. That's the worry about how this is written at this point in time and what could potentially happen, particularly if you're not involving the regulators in determining what that scope ought to be.
Thank you very much. I missed, was that was MLA LeBlanc's question? No. So I'll recognize MLA LeBlanc, please. Thank you.
Thank you, Mr. Chair. Thank you, Mr. Alec. Just want to touch on this kind of in the same way that Ms. Regan has just done, but the idea of the public interest. The definition of public interest is changing or changes depending on, who might be in power or where you are in the world or whatever. So it seems to me the public interest in Nova Scotia often can mean cheaper, right? And I just want to know if you in your organization or if in your practice you have seen the effects of this public interest equals cheaper on clients or on your members.
Yeah.
Go to the speaker, please.
No better place to see this than in the provision of social care in our province, where, again, government has continued to download responsibilities to usually untrained, unqualified staff to be able to care for vulnerable people. Again, I know we're talking about health. I'll talk about social care for a minute. The continued use of places of safety is an example of this, right? Where we have unregulated, untrained staff providing care to very, very complex cases. This is a continuation of what happens when we don't assure quality care, when we're not looking at greater public safety, and we're looking for the cheapest option. So that's a concern when we're talking about, again, the broader political context, the role of regulation within it, and the narratives that stem from it. Again, some of the language, even in presenting of this bill, of reducing barriers, is an undermining of what regulation is meant to do, which is to instill public safety. So that's part of the problem with how this bill was enacted, how it was brought forward, and the lack of consultation. Again, as you noted, all of this could have been resolved by sitting around a table with regulators and working with them. In my opinion, it did not need to be done in this way. That, again, I think in the long run impacts the integrity of regulation.
30 seconds, MLA Di Constanzo.
Thank you, Chair. And just quickly, you touched on it, and it's been a big concern of mine, is the new announcement for the 1-hour session that they're allowing social workers to do mental health counseling as the first session. What is your opinion on that, and are they qualified to do that?
Speaker.
Yes. Social workers are totally qualified to do that. The question of, is that the best, again, getting a little off the plot, but is that the best mechanism for delivering mental health and addiction services? To that, our assessment of that particular policy approach would be it is not. Again, expansion of the public system is what is required to deliver mental health and addiction services in an ethical, safe, and competent way.
Wonderful. Thank you very much for your comments and your time today. We'll move on now to our next speaker. We have now reached our 9 speakers. This will be our 9th speaker. So I would remind speakers going forward from this point, you have 5 minutes to present to the committee, and the committee continues to have 5 minutes to ask for questions. So we will move on to our next speaker. Our next presenter is Sue Smith. And I would ask you if you could identify yourself for the committee members and any organizations that you may belong with. And I believe there's 2 of you, so you could both, and then I'll start your time.
Thank you. Opportunity. Hi, folks. I'm Sue Smith, the CEO and the Registrar of the Nova Scotia College of Nursing, NSCN, and with me is Heather Totten, and she's our General Counsel and Senior Director of Governance. You may refer to me as Sue or Ms. Smith, and you may refer to Heather as Heather or Ms. Totten. We're really appreciative of this opportunity and want to convey, like our colleagues as well, our support of the intent of the Patient Access to Care Act, while strongly suggesting legislative revisions that leverage the expertise of Nova Scotia's experienced regulators like NSCN. You'll see it outlined in the submission that we have put forward. NSCN regulates licensed practical nurses, registered nurses, and nurse practitioners, and we're over 16,000, the largest health profession in the province. With that legacy of regulation, our predecessor is the oldest nursing regulator in Canada. NSCN has progressive and flexible registration and licensing process that allow us to respond to evolving healthcare needs. The intent of our processes are to ensure that only those healthcare providers who are qualified to provide safe, competent, and ethical care do so. We've been making a lot of changes since we became the one college for all nurses in 2019, and we have the benefit of a very flexible new Nursing Act as well. During the unprecedented days of COVID-19, NSCN led the country in bringing back to license retired nurses. And over the 3 years of COVID, we brought back over 5,000 retired nurses and worked closely with government on that. Building on what we learned on the time, we recently announced significant, first in the country, registration and licensure changes. Effective Wednesday, March 29th, we're reducing the overall application process for other Canadian jurisdictions from up to 5 days to 24 hours. Effective May 1st, we'll reduce the overall application processing timeline for nurses from Philippines, India, Nigeria, US, UK, Australia, and New Zealand from over a year to a matter of few weeks. And we have done this based upon the regulatory expertise that we have developed over the years and the determination that those countries have the exact same scope of practice as a nurse who has been educated and licensed in Nova Scotia. I'll now address the patient access to care specifically, Bill 256. We support the goal and we echo the comments of the Minister around collaboration. As a regulator, we have demonstrated the ability to act quickly, especially with the benefit of very modern and flexible legislation. We welcome the accountability outlined in this bill, but we recognize the need for regulatory expertise, and we value the public protection that the regulator brings to the table. We have 2 areas of concern that are outlined in our presentation. The waiver of registration and licensure requirements. We know that the purpose of the bill is to remove barriers, and we have demonstrated our commitment to this process with our innovative changes to registration and licensure, for example. And we've leveraged that regulatory expertise, and we believe that that expertise, working with key stakeholders, will make a significant difference. There are 2 public safety elements that are missing from the bill. The applicant must be licensed to practice in an equivalent scope of practice in their home jurisdiction, and that the applicant is not subject to disciplinary proceedings or limitations on their ability to practice in their home jurisdiction. In our expert opinion, these 2 criteria will allow the public to continue to be confident in the healthcare providers. I would like to direct the committee to our direct suggestion for language in Appendix A. The other aspect, the second element, is expanded scope of practice. That defines the outer limits of practice, and we have had actually quite a few years' experience in this area, particularly with the legislation that we have. We support the concept and principle. However, the bill as currently drafted does not incorporate the role of regulators in authorizing healthcare providers to engage in expanded scope of practice. In our opinion, the regulatory authorization is a key element that will allow experienced regulators like NSCN to use our expertise to make that difference. In context and legislative language, for example, I'll give you an example of the expanded scope that we brought in. In January 2022, NSCN introduced the registered nurse authorized to prescribe RN-AP. RN prescribers, so these are different from NPs that prescribe. RN prescribers are registered nurses with an expanded scope of practice that enable RNs with specialized education and skills and use their specific criteria in collaboration with the nurse's employer. Our proposed amendment to the Patient Access to Care Act is based upon our experience.
If you could pause just for a moment, please. Thank you. So that is your time, but I'm going to ask committee members if they're not opposed. I do have 2 speakers that are here at the table, and I'm willing to extend 5 minutes for the other speaker. Is there any objection to that? you can carry on, and you
Thank
can
you
use
so
Ms.
much.
Todden's time.
Thank you so much. Well, we're going to tag team. I was doing this part, and Ms. Totten or Heather can answer questions, and I was going really fast. We're just in conclusion. While we've had the opportunity to provide feedback on the contents, we are grateful for this occasion to present. We hope you'll find that our submission, although it does outline the support, you get the importance of including regulator authorization and safeguards to protect the public. As a member of the network of the regulated health professions of Nova Scotia, we remain committed to our collaborative relationship with the 21 other member bodies, and we look forward to ongoing collaboration with the government and other key partners in healthcare to continue to make innovative and impactful decisions. Thank you, and if Heather, Ms. Totten has nothing else to add, you can, if possible, direct questions to Heather, and that will be her turn.
Thank you very much. And so we will go to questions now. I'll start out with MLA Regan, please.
For coming in today. A lot of our presenters have sort of focused on the safety aspect and also the trust in our health professionals that's so necessary for the public. Could you give us an example of what happens when you bring in a nurse who is not licensed to practice in a way that we've come to expect here?
Recognizing Ms. Todd.
What could be the implications?
Ms. Todden, please.
Great, thank you very much for that question. And so, like many of our colleagues who spoke before us, there could be significant consequences to bringing in health professionals, including nurses, to Nova Scotia that haven't been educated and licensed to the same scope of practice and to the same standards of practice that we expect of nurses here in Nova Scotia. It's a fallacy to think that nurses simply carry out orders, right? That was something that maybe you saw in the 1950s. Nurses, as well as many other health professionals on the entire healthcare team, need to engage in critical thinking and decision-making as they care for patients here in Nova Scotia, particularly with respect to how ill people can be and how rapidly their condition can change. So without that foundational education and licensing and scope of practice, you might have health professionals, including nurses, just not being able to recognize and be able to provide the care that's required in this situation.
Thank you. Go to MLA LeBlanc, please.
Thank you very much, and thank you for all of the work that the college or your, is it college? Yeah, that has been doing, like the changes that you've made and the way you've been reacting to our present situation in healthcare has been quite inspiring. I'm wondering, and this is, you know, maybe a controversial question, but when we hear the minister talk about collaboration, and I've spent a lot of my life collaborating in various ways, I wonder how it felt, if you can describe that in any way, when you see this piece of legislation tabled that literally no regulator was kind of consulted with and therefore really didn't collaborate with, and that there's this like intention of collaboration, but there was no collaboration in the presenting of the bill.
Ms. Todden?
Great, thank you very much. Of course, we would have appreciated being consulted prior to the bill being introduced in the House. However, we understand that this is not an unusual occurrence. What's important for us is that we have a long history collaborating with the Department of Health and Wellness with respect to regulation of nurses, as well as our participation on the network with respect to regulation of all health professionals in Nova Scotia. At this point, we have no reason to believe that that will be any different on a go-forward basis, particularly with respect to the reference earlier that a lot of the details of how this act will be implemented will be contained in the regulations. And so we fully expect and believe and trust that we will be engaged in these regulations because of the significant level of regulatory expertise that will be needed to draft those regulations.
Thank you very much. MLA D. Costanzo?
Sorry, just a quick question. You mentioned RN-AP. So I'm familiar with LPN, which is a 2-year course. RN is a 4-year course. Is this something that they're learning on the job, or how, and what is the pay increase, and how does it work?
Ms. Todden?
If you're, just to clarify, you, with respect to the RN authorized prescriber or with nurse practitioners?
MLA D. Costanzo?
RN-AP. I'm not familiar with that one.
Back to Ms. Todden, please.
Great, thank you. Registered nurse authorized prescribers are licensed registered nurses who have undergone additional education. Right now, that education is at Dalhousie University, where they are educated on how to prescribe. So all the safeguards around learning more in-depth knowledge about pharmacology and how to prescribe in appropriate circumstances. Once they demonstrate completion of that education, then they apply to us for authorization from the regulator to be able to carry out that role in the workplace, which currently is contained within the Health Authority and the IWK at this point, because this is a new role and we wanted to evaluate it initially to see how it was working, and it's working very well.
How long is the course?
It's 3 terms.
All right, thank you very much. That concludes our time for questions. Thank you so much for coming and presenting.
Thank you very much.
Moving on now to our next presenter, Kim Ramsey. Once again, I would like to point out you have 5 minutes to present to the committee with 5 minutes of follow-up. If you could identify yourself for the record, as well as how you would like committee members to refer to you, and if you're here representing any organizations as well. And once you've done that, we'll start your 5 minutes.
Thank you for having us. My name is Kim Ramsey. I am here on behalf of, I'm the Vice Chair of the Nova Scotia College of Chiropractors, and this is John Sutherland. He's our Executive Director. You can refer to me as Kim or Ms. or Dr. Ramsey, and John or Mr. Sutherland.
Okay.
Thank you. On behalf of the College of Chiropractors of Nova Scotia, I would like to thank you for the opportunity to comment on Bill 256. We recognize the work that has been behind this bill and the priority of this government to improve access to health care for all Nova Scotians. The board of the Nova Scotia College of Chiropractors supports improvements in health care delivery that result in increased patient access to care. Chiropractic was one of the first professions to embrace the original agreement on internal trade over a decade ago. The chiropractic profession has already established a reciprocal recognition of educational standards internationally. We are strong proponents of mobility within Canada and outside of our borders. It only makes sense that competent, ethical practitioners safely practicing elsewhere would be equally able to practice safely here in Nova Scotia. We would like to draw your attention to 2 areas of the proposed Patient Access to Care Act where additional clarity would enhance our ability to ensure public protection while also expanding admissions and roles for registrants. Firstly, there is some concern in interpretation of Section 3 in the definition of expanded scope of practice area. Our submission outlines in detail our concern for clarity for both registrants and regulators. The College of Chiropractors supports expansion of scope of practice to the full level of professional training and competency. Chiropractors are an underutilized profession in healthcare delivery in Nova Scotia as primary healthcare providers with the training and skills to examine, diagnose, and provide treatment recommendations for neuromusculoskeletal conditions. There are opportunities for chiropractors to reduce the burden on our fellow healthcare providers. Chiropractors should be able to directly refer for services within their scope and training, such as x-rays and advanced imaging, and also lab work related to neuromusculoskeletal conditions, further reducing demand on the healthcare system. Also, current requirements for additional medical appointments and paperwork in order to access chiropractic treatment imposed by insurance companies places an unnecessary burden on our already taxed medical system and on our patients. Additionally, in Section 5, subsection 2, there is a need to better define the term good standing. The term is defined differently or not at all in other jurisdictions. For established practitioners transferring from another province or country, perhaps one of the most important measures of public safety is their individual regulatory history. It is critical that regulators be able to screen practitioners who may have current or prior practice limitations to ensure that Nova Scotians are not put at risk. The College of Chiropractors of Nova Scotia will make all necessary changes to enhance mobility for all applicants in a timely manner and ensure that due diligence continues to protect the public. We look forward to working with the Governor and Council to establish regulations that allow chiropractors to continue to provide safe and competent services to Nova Scotians to our full level and training and scope of practice. We have been an underutilized resource in this province and have almost 200 registrants that are trained, regulated, and available to reduce the burden on our healthcare system, and in so doing so, improve access to care. Thank you for the opportunity to comment on Bill 256. Providing excellent and competent healthcare and healthcare providers to Nova Scotians must be the focus for all of us as we find solutions together. Thank you.
Thank you very much. Mr. Sutherland, did you have any comments? You still have about a minute.
No, thank you, Mr. Chairman. I'll defer to questions from the committee.
Okay. Thank you very much for your presentation, and we will do that now. We'll go to committee members, and the first questions will come from MLA Boudreau, please.
Thank you, Mr. Chair, and thank you, Dr. Ramsey and Mr. Sutherland, for presenting today. And as a registrant in the college, I can say I appreciate all the work that you do to support us chiropractors in the province, and certainly doesn't go unnoticed. And it would be remiss to not ask a good question while I'm here, and this is maybe one that's a bit different than some others might ask, but in terms of how chiropractors, the role of chiropractors, what would expanded role, what would an expanded role be in the world of chiropractors? What would an expanded scope of practice look like?
Go to the speaker, please. Sorry, to Ms. Ramsey, please.
Thank you. An expanded role for us would be to the full scope of our professional training, and we've never really been able to do that here. So that would include things like having direct access to radiology services, having access and advanced imaging, and having access to lab. And so if we could do that, our patients would not have to be sent back to their family physicians to bog down appointment time and financial strain on our medical system. We'd be sending them for the same x-rays and lab work they'd already be getting. So that's a lot of reduced time within our medical system. We just want the full access to what we're trained for. And so I think that answers your question.
Thank you very much. And I'll go to MLA Regan, please.
Pretty much the same question I've been asking everybody in terms of bringing in people from elsewhere who may have different standards in training. What happens when they don't meet the safety standard?
Dr. Ramsey?
Well, we already have international reciprocal agreements. So in order to be licensed here in Nova Scotia, you have to meet that standard. And at this point, if you don't meet the standards, the same as with nursing or all other colleges, our registrants or applicants would have to meet the standards in order to be able to practice here. Does that answer your question? Or not quite?
MLA Regan, please.
Not really, because they're talking about expanding that and no longer having the same kinds of, I guess, tightness around who gets licensed. Yeah. So if you could. Have you had any experience with people who come in and claim that they have training that they don't have? That's sort of what I'm getting at.
Dr. Ramsey?
I'm going to defer to Mr. Sutherland for that because he would have more access.
Mr. Sutherland.
Thank you, Mr. Chairman. So in the profession of chiropractic internationally, there is an international system of accreditation of chiropractic programs, which is overseen by the Council of Chiropractic Education International. So an international graduate of one of those programs coming to this country would have to indicate that they graduated of an accredited program. And in addition to that, they would have to write the Canadian Chiropractic Board examinations, which is an additional measure to ensure that the competencies and standards that they're required to maintain in Canada, including this province of Nova Scotia, are met. Thank you, Mr. Chairman.
Thank you very much. Any other questions? MLA Di Constanzo.
De Costanzo. Sorry, thank you. And I know that we do not have a school here, correct? And there's only 2 schools in Canada. If you want us to be a chiropractor, you got to go to Ontario, to Willowdale. I know that's where it is. And the other one is in BC. Anyway, is there more? How many schools, and why don't we have it here? And when do you hope that chiropractic become like physiotherapy, access in the hospitals?
Dr. Ramsey, or no, I will go to John Sutherland, please, with 1 minute.
Thank you, Mr. Chairman. The 2 schools, there's one at Canadian Chiropractic Memorial College in Toronto. The next one is the Francophone program at Université de Quebec at Trois-Rivières. And so a large number of our Canadian students would go through both of those 2 schools. There is not currently a school in British Columbia. A large number of practitioners in Canada have been trained in schools in the United States, and those schools are accredited under the United States Council of Chiropractic Education, which is in close collaboration with the Canadian Council of Chiropractic Education. So again, the matter is about accreditation of the schools where people are trained. So not to say that there couldn't be additional chiropractic programs at some point set up in Canada, but the importance is that those programs be properly accredited so that the competencies and the standards are met. Mr. Chairman, I apologize for running over time.
It's okay. Thank you both very much for your time today and your presentations. We appreciate your time. Thank you. Moving on to our next speaker, and in case you weren't in the room earlier, I've become known for butchering people's names, so Carl. And if you could identify yourself for committee members, how you would like to be addressed, and if you're here representing any particular organizations. Once you've done that, we'll start the timer. You have 5 minutes to present with 5 minutes to follow up.
Great. Thank you, Mr. Chair. My name is Carl Kowalczyk. I'm the Executive Director and Registrar with the College of Paramedicine Nova Scotia, and please call me Carl. So if I can, our college regulates the practice of paramedicine in Nova Scotia. We're statutorily obligated to and mandated to serve and protect the public interest in the practice of paramedicine. It is from this public interest lens that the college offers its comments regarding Bill 256 today. In principle, the college supports the purpose of Bill 256. However, we agree with the network's position that the proposed legislation could benefit from amendments, increased clarity, and revised definitions to better reflect the terms used in existing regulatory statutes. In our submission, we expressed concerns related to the legislative process of Bill 256 and some of the consequences regarding provisions of the bill related to the registration and licensure of applicants from other jurisdictions. First, let me address the concern about the legislative process and our college's experience with seeking amendments to the Paramedics Act and the regulations. While I recognize this may be redundant to say, the government's self-regulated professions policy has a stated objective. It's to ensure the Treasury and Policy Board receives complete, accurate, relevant information upon which decisions respecting self-regulation professions can be made to improve the quality and consistency of submissions. To receive complete, accurate, and relevant information regarding Bill 256, consultation should have included key stakeholders. Our college is still relatively young. However, within the first 6 months of our college's operation, we identified several aspects of our legislation that impacted our ability to operate effectively and efficiently. So we approached the government about taking necessary steps to amend the legislation. In doing so, we identified over 50 stakeholders to consult with, and we consulted with those 50 stakeholders. This bill, too, is worthy of consultation because it impacts components a healthcare profession's regulatory responsibilities. However, we understand there was minimal, if no, consultations regarding Bill 256. Due to the speed of which the bill is moving through the legislature, our college didn't even have the opportunity to consult with our council. This means that the government missed the opportunity not only to consult with registrants, but with public representatives appointed by government to our council and to the other boards of the other regulators. The government's stated primary purpose for permitting self-regulation is to address the risks of harm and serve the public interest. Self-regulation is granted to organizations when there are substantial risks of harm to clients and patients, and self-regulation is the most efficient and effective means of addressing them. We interpreted this to mean that the Nova Scotia government recognizes the profession knows itself best and is in the best position to regulate in the public interest. The regulated health professions have an ethical and legal duty to put the interests of patients and the public ahead of all others. I'm here today representing the college to serve and protect the public interest by addressing aspects of the legislation as they pertain to the registration and licensure process. Our organization can and does license individuals within 2 business days regularly. We, like other regulators, have a straightforward online application process where it connects electronic applications to all the college's registration and licensure policies. The process for completing electronic applications, submitting the required documentation, and paying the registration license fees is efficient and timely. That stated, the college is also very pleased to advise the committee that since its inception, several individuals have been denied registration or licensure or have withdrawn their applications from the college because of concerns that were risen during the application process. We cannot overemphasize the risk to the public if applicants are not screened effectively against the criteria for registration and licensure. Every day in Nova Scotia, paramedics are called upon to work in very unstructured environments with access to the province's most vulnerable populations. Just before the college's inception, a paramedic was charged and convicted of sexually assaulting a vulnerable senior citizen. That paramedic was on duty and in uniform when that occurred. Before this, there were 2 other well-known cases where one paramedic was convicted of child pornography possession and another was luring minors. The requirement for good character is indispensable to a profession's ability to self-regulate. Regulated healthcare professionals have a special relationship with the members of the public, rooted in mutual trust, confidence, and respect which is critical to effective practice. The purposes of good character requirement include protecting the public, maintaining a high ethical standard, and maintaining public confidence in the paramedic profession. Integrity, honesty, and governability are fundamental qualities of any individual who seeks to practice as a member of the paramedic profession. Regardless of how competent a paramedic may be, if personal integrity, honesty, or governability is lacking, the paramedic's usefulness to the patient and the reputation within the profession may be destroyed. The college continually identifies and effectively manages applicants of concern. These applicants include those who are terminated from their employer, recently received regulatory professional conduct histories, recently had weapons charges, theft over $5,000, and assaults including sexual assault.
And that would be your time. Thank you. We do have a number of MLAs who have some questions, so I will start with MLA Regan, please.
I noted during your presentation, and thank you for giving us a copy of your remarks, that you talk about the college taking action and not allowing the licensure of certain people, and you note that it protects the public, right? That this whole process protects the public. What happens if we don't have that process?
Go to the speaker, please.
Sorry, Chair. So if we don't have that process in place, these individuals will be able to gain access to the most vulnerable. You got to imagine that when a paramedic is going to a home or going to a scene where there's vulnerable patients, and I can speak from my own experience, where I'm walking to the house of an 80-year-old lady who is there by herself. There's no other person there to look after her. She's counting on us to manage everything, not only about her care, but about her environment. You know, there's the risk that there's the potential for paramedics to take advantage, as has already been described. And that incident actually occurred with another paramedic on site, and that person was pulled to another room. So there's many risks if we aren't able to screen these people effectively for criminal convictions, good character, incapacity, incompetency, if they have professional liability insurance, or even have language proficiency. There's all risks to the public if that's not in place.
Thank you. I'll go to MLA LeBlanc, please.
So this piece of legislation is coming to us because we need to speed up the process of getting health professionals, ready to work in Nova Scotia. And for sure, we know that many paramedics are leaving the profession. But it sounds like in terms of the paramedics being ready, like you said, you can process an application within 2 days, which is very fast. So I'm wondering if you can speak to other things that paramedics or the paramedic profession might need in order to make sure we have enough paramedics on the ground and that paramedics are able to stay in their job.
Well, if I could.
Sorry, I'll go to speaker. Thank you.
I can mention that in our database, we currently have a listing of approximately 1,800 registrants. Out of that 1,800 registrants, we only have about 1,300 that register on an annualized basis. So we've only been in existence for 6 years. So the question should be posed, where are these paramedics going and why are they leaving? I think things could be looked at from a systems perspective to see how things could be managed and changed within systems to help retain paramedics in the system.
Thank you very much. Any other questions? If MLA Smith, please.
Thank you very much. Thanks for being here and your presentation and the submission. We really appreciate it. And just want you to know that, as we've said to some other presenters here today, the things that have been submitted today are going to be considered by the department. So just want you to know that. And thank you and the folks you represent for the work you do.
And with that, thank you very much for coming forward today. Appreciate your time. Moving on to our next speaker, Dr. Carl Davis and Sheldon Poirier. Pache. I can't let the people down. I have to mess up the names. I apologize. So as with previous speakers, I'll have you identify yourself, how you would like to be addressed by committee members, and if you're here representing a particular organization, if you could identify that as well, and then we'll start your 5 minutes for your presentation. So I'll let you introduce yourselves, and then we'll start the timer.
My name is Dr. Carl Davis. I'm optometrist. I'm legislative chair for the Nova Scotia College of Optometrists. I'm joined by my colleague, Dr. Sheldon Pache. He's the registrar for our college. And you can refer to me as Carl. That would be fine.
Sheldon.
So, thank you for this opportunity to comment on the proposed Patient Access to Care Act. We are overall encouraged and in support of the theme that government has proposed. Due to time constraints, as was kind of touched on previous presenter, due to time constraints, we did not have the opportunity to review this proposed legislation with our college or our legal counsel. Therefore, we will include our voice with the submission from the Health Regulatory Network response, who will be presenting later this afternoon. However, one specific area that we hope for eventual clarification is in regard to the acceptance of candidates from jurisdictions outside of Canada. This would pertain in the Act to Section 5, subsection 2, Section 6, and Section 8.1, subsection D. Optometry in Nova Scotia is one of the few regulated health professions where we do not have an educational program. We do have 2 Canadian schools, one at the University of Waterloo and one at the University of Montreal in Quebec. In addition, however, though almost 50% of Canadian optometrists have been educated in the USA. So while we of course recognize the qualifications of the 2 Canadian schools, we currently also accept the qualifications of the 24 American schools. For us, the question is regarding international applicants. Outside of North America, the competency, the skill set, and the scope of practice of optometry can vary significantly throughout the world. So as the legislation has been presented, the question for us is, will we be forced potentially to accept candidates who may not be competent? We are a small college. We're 155 members. Our resources to assess the educational criteria of international applicants is limited. That's not to say, however, we've not been dealing with this issue. We do recognize the importance of allowing new Canadians the opportunity to practice their chosen profession in our province. To this end, the NSCO, along with our provincial counterparts, have created a credentialing assessment program for non-American trained optometrists. This is a program provided in Ontario. Being a small college, again, we rely on this body to perform this very important function. So, in keeping with the regulator's priority of protecting the public and requiring competency in its members, we request and hope that this act will provide individual regulators the flexibility and opportunity in determining which applicants from non-Canadian jurisdictions are permitted to provide care to the residents of Nova Scotia. Thank you.
Thank you very much for your comments. Anything, Sheldon, or is that okay?
Mr. Speaker, the only thing I'd add is that
going to speaker, please, Sheldon. There you go.
Yeah, the only thing I would add is that in optometry, we are part of a North American accreditation process. So it's not unique to Canada. Our 2 Canadian schools participate with the 24 American schools for accreditation.
Thank you. So I will go to members of the committee now for questions. MLA Regan, please.
Thank you very much for coming in. I went to University of Waterloo, but I didn't go to the optometry school, so there you go. But I did, and I have had optometrists who went to Waterloo, but also came through the American system. So in terms of the training that happens elsewhere in other jurisdictions, you said, their competencies may be different. Could you give us an example of what those would be, for example?
I'll go to
I'll answer that.
Sheldon, please.
So if we're talking about non-North American trained, it varies quite a bit. And the biggest changes in our scope of practice over the last 25, 30 years. And so, for instance, our British colleagues are just getting into the expanded scope that we've had for several years. So they're adding that to their program. If you go to other countries around the world, optometry's only been recognized as a profession for less than 20 years. So the biggest difference has to do with therapeutics and the treatment of eye disease is the biggest change in scope. Okay.
Which would be nil in some Asian schools.
Thank you. Any other questions? If not, thank you both so much for your time today. Have a wonderful afternoon. Moving on now to our next presenter, Kevin Wong. Hi.
Hi there.
Thank you for coming today. I'll get you, as with the previous presenters, if you could identify your name for the record, as well as how you would like to be addressed by committee members. And if you're here representing any particular organizations, you'll have then 5 minutes to present with 5 minutes of follow-up questions. I'll let you introduce yourself.
Hi, good afternoon, everyone. My name is Kevin Wong. I am the Executive Director and Registrar with the College of Occupational Therapists of Nova Scotia. And you can call me Kevin, or you can call me Mr. Wong.
Thank you very much. I'll start your time now.
Thank you very much, Mr. Chair, and hello, committee members. I come before you today representing the College of Occupational Therapists of Nova Scotia to provide feedback on Bill 256. A little about our organization. The College of Occupational Therapists of Nova Scotia has regulated occupational therapists since 1998, and we are a creature of the Occupational Therapists Act. We have about 730 registrants licensed in our province. Occupational therapists are university-trained healthcare professionals that provide a wide array of physical and mental health services throughout the province and in numerous practice settings. You will often see an occupational therapist in a hospital, schools, clinics, and also working in the homes of Nova Scotians. With respect to Bill 256, the College of Occupational Therapists of Nova Scotia stands behind the joint submission of the Regulated Health Professions Network, and we share the same concerns of our regulatory partners that you have heard from today. It should be acknowledged that we agree in principle with the need to improve access to care, and many components of Bill 256 are positive. However, there are some areas of concern with respect to some sections of Bill 256. The current language of the Act could be problematic for the regulation of the profession, as it removes some safeguards and may result in some unintended consequences. I think that's a phrase you've likely heard a little bit today. As a regulator, our mandate is to regulate in the public interest, to ensure that Nova Scotians receive safe, ethical, and competent occupational therapy services. In Bill 256, Section 7 includes expanded scope of practice language, and the College supports this in principle. However, the current language allows our registrants to practice potentially in an unregulated space outside of the profession. As a result, we would be unable to appropriately regulate these professionals. Like other professions, one unintended consequence of this will be professional liability insurance. If you are operating outside of your scope of practice in the profession, you are not covered by professional liability insurance. As a result, if the current language in this bill remains with respect to this section specifically, this will leave registrants without professional liability insurance coverage and may leave Nova Scotians without compensation in the event of an issue. We also have concerns with respect to the blanket registration waiver provisions for jurisdictions, in particular outside of Canada. Section 8(1)D, there exists a wide range of variation between healthcare professional education programs in some countries. In occupational therapy, we currently have a national process of determining educational equivalency for those that receive their occupational therapy degree outside of Canada. This process is called CEES, and this determines educational equivalency and provides resources for gap filling for these applicants. This helps to ensure that applicants have a foundation of education and skills prior to coming to the province or to Canada. In fact, CEES process and our national credentialing exam can all be completed online, which means that many of our applicants can complete this before even entering Canada. It is possible to make improvements while keeping safeguards in place. The current Bill 256 removes some of these safeguards. The system can improve, and this is best achieved when regulators and government can collaborate. Overall, identified in our submission, we request these amendments to Bill 256 as indicated in our joint submission through the network. These amendments will provide an opportunity to provide flexibility to the regulator to adjust requirements when it is safe to do so, and may prevent significant issues by keeping these important safeguards in place. Thank you, Mr. Chair.
Thank you so much for the presentation. I go to the members for questions. MLA DiCostanzo.
Thank you. Thank you, Chair. And thank you, Mr. Wong. And just to give me an idea of OT, are there many occupational therapists who are working privately, or are the majority? If you can give us some numbers of what is happening. The ones I've worked with have always been within the public service and in the hospitals, or the ones that visit at home. But what is happening in the profession, and is that something that can be independent as a private practitioner as well?
Mr. Wong?
Thank you for the question. I think approximately 20% of occupational therapists in the province work privately. So that includes essentially outside of NSH and IWK. So that could include those that actually are contracted by veterans privately, but also small private clinics, LifeMark, CBI, for example. The expectations, I think, for those that work privately and publicly is the same. The standards of practice are the same regardless of practice area. So I hope that answers your question.
MLA DiCostanzo.
As a follow-up, so we do train them here in Nova Scotia, and the training and the standard, they have to pass the exams. And are you having any issues or any problems with the scope right now?
Mr. Wong?
I think occupational therapy as a profession enjoys quite a broad scope of practice right now. And I think the concern is that by expanding that scope of practice outside of the profession, where there's expertise into where that education comes from and what you're able to apply in practice, I think that's a concern because of our actual enjoyed broad scope already. So I would maybe just take this opportunity to indicate that it's important that the regulator be at the table when there is any expanded scope within the profession, and we certainly would not support any expansion of scope outside of the profession at this time.
Are there any other questions from members? Seeing none, thank you so much, Mr. Wong, for your presentation.
Thank you.
I will ask for next witness, Beverly Swicker. So while we hand out the handouts, Ms. Swicker, maybe you can provide your name and if you represent an organization, as well as how you'd like to be addressed during questions.
Certainly. Beverly Zwicker. I'm the CEO and Registrar of the Nova Scotia College of Pharmacists. You may address me as Bev or Ms. Zwicker.
Okay, thank you. Let me just... Okay, thank you. Everyone has one? Okay. Ms. Zwicker.
Thank you. The Nova Scotia College of Pharmacists is the regulator of the profession of pharmacy in the province, and we govern the practice of over 1,700 pharmacists and pharmacy technicians and the more than 300 community pharmacies where they practice. As government's trusted partner in working for the public interest, we are actively working towards health solutions for Nova Scotia. We agree with the need to both increase the number of licensed healthcare professionals in the province and the opportunity for the public to have access to the full scope of healthcare that these professionals can provide. We agree that regulatory nimbleness in the area of licensing and scope of practice is critically needed, and that is why we support Bill 256. We've been provided with assurance from the government about its intent, and we are here today to recommend amendments so that the language better ensures these intentions are realized in its implementation both now and in the future. You have heard many recommendations today from colleagues. Our recommendations align very much with those, and you'll see them attached as an appendix to my submission, including those from the Network of Regulated Health Professions as presented by Mr. Baxter. The NSCP is bringing forward these recommendations as the expert in regulating the profession of pharmacy and with a demonstrated commitment to proactively updating scope of practice and licensing requirements in the context of evolving public interests. Our work over the last several years has benefited the public of Nova Scotia in having a profession of pharmacy in the province with the broadest scope of practice across the country. We are now working with our healthcare system partners so that pharmacists are repositioned more fully in primary care so that the public has the opportunity to access this broad authorized scope to meet their healthcare needs. We are also actively working to streamline licensing requirements while making sure that those that we license have the capacity to competently and ethically bring care to patients in their pharmacy. Some examples. Early in the COVID-19 pandemic, we asked government to provide us with the authority so that we could license new grads, even though the exam had been suspended. We were the first and one of the few regulators in the country to do that. More recently, we have just opened a licensing pathway for pharmacy assistants so that their experience can be recognized in becoming licensed as a technician, which we give them regulated scope and oversight. We have worked with our counterparts across the country to establish a quality assurance and professional accountability framework for cross-jurisdictional practice, and we are encouraging a pan-Canadian review of licensing requirements for pharmacy professionals who are trained internationally. Strengthening licensing requirements is an important, strengthening and streamlining licensing requirements is certainly an important focus of regulators right now. But any work we do in this area must be undertaken with care to ensure that we only license those with the capacity to competently and ethically practice. You will see in our submission that we have outlined suggested draftings that we feel will only help to strengthen the intent of the Act. And we have 3 priority areas that we feel need to be addressed. A strengthened purpose statement, and that has been eloquently addressed by a number of my colleagues, and so I won't repeat those, and I've set them out in the submission, other than to say it's a serious omission not to amend this. Without the language, future interpretations of the Act may not strengthen the critical interest of ensuring competency, not just training. Clarify good standing. And again, my colleagues have done a wonderful job in articulating why this amendment is needed, and so I won't spend time on that other than to say we have suggested some specific amendments, again in the appendix, that are alternatives for you to consider. And we've also encouraged embedding the regulator's role in the expansion of scope of practice. And again, that has been well articulated, and so I won't repeat that, other than to say this is really critically important, to involve the regulator of the practitioner for whom scope is going to be added, so that we're sure that standards are established and that it is clearly within the practice that's insured by the individual's professional liability insurance as well. So I'm here today to propose solutions to moving forward. I appreciate the opportunity to speak with you and for your consideration of those. I will say that while it's imperative that we continue to look at ways to increase the number of licensed healthcare professionals, increasing numbers without meaningfully transforming the way healthcare is provided will not solve our healthcare crisis. Now more than ever, we need to shift our attention to not just getting more, but using more effectively. And I would encourage communications around Bill 256 to focus on the need to use more effectively, not just in getting more numbers.
Order.
Appreciate that.
Okay, thank you so much for your presentation. We'll start with MLA Di Costanzo.
Thank you. Sorry, I just got a name here. Sorry, just figuring the name. Mrs. Wicker, I thank you for the presentation, and I've got a couple of questions. But the first one, and everybody talked about this today, is the training is one thing and competency is another. And you also have the issue of pharmacists who've been in the business for a long time, and education has changed, especially now when you've got PharmD, correct? Maybe you can explain how is that going to work? You know, are they being trained on a larger scope now that they are PharmD? Are you including that in the part of the training? And what happens to the pharmacists who have already been working for 10 or 15 years? There's already the ones who've graduated in the last 5 to 10 years see that the ones who graduated 20 years ago are lacking the information. How are you going to be able to keep up with the training and the enlarge of scope? There is, you know, and it's optional, correct? So not every pharmacist has to take this expanded scope. Questions.
Ms. Swicker.
Yes. Thank you. The scope that pharmacists are now being able to provide to the public has been authorized since 2011. Pharmacists have been trained and competent to provide that for at least 20 to 30 years. Certainly now there is a PharmD. The PharmD program allows for an expanded opportunity for applying the taught skills in clinical practice, but the foundational information and training is there. Pharmacists who were licensed in 2010, certainly even in 2000, there is a requirement and expectation that they engage in ongoing continuing education. So they would have been building their knowledge, their competency as new information and new areas of practice became supported in the curriculum. I hope that addresses your question.
MLA Boudreau, and then we'll come back. MLA Boudreau.
Thank you, Mr. Chair, and thank you for your presentation. I like my colleague, have family member who is a pharmacist, and so that's why I think the two of us are interested in asking questions. Something that piqued my interest that you talked a little bit about was about the roles of pharmacy assistant to technicians. And so my wife works in a community pharmacy in a rural area. You know, the scope has grown for pharmacists, which is exciting, but there are some things that technicians can do that assistants can't do. And so maybe could you talk a little bit about what that program is going to do, or the envision of kind of getting assistants or to that technician qualification?
So as a regulator, we created
Sorry, Ms. Swicker.
Thank you. So as a regulator, we created another group of pharmacy professionals in the profession in 2013, the technicians, so that they could have the responsibility and accountability to complete the technical aspects of pharmacy, primarily related to the distribution of drugs. This is intended to free up pharmacists to have more time so they can bring their clinical knowledge and expertise in assessing patients and being the lead of patients' drug therapy, which is really the primary role of the pharmacist, and nobody better on a patient's healthcare team to lead drug therapy management than the pharmacist. So by creating a practitioner that has skills specifically for drug distribution, does not require a 6-year pharmacy degree. It allows the operations of a pharmacy to better allocate the workload across its workforce. Does that answer your question?
Yeah, I think so. I'm excited about the idea of
Thank you. Oh, MLA Boudreau.
I can talk for hours, but just in the idea of giving the assistants that ability, like that, how are you managing that? Is there courses that they're taking to get there? Like, what is it that they're?
Yes.
Yeah.
Ms. Swicker.
Yes, so we've been working in parallel while we were waiting for our regulation changes to be approved with the education providers so that there'll be a bridging program. So their time as assistants can be recognized towards their licensure, and they can have an abbreviated education program, ideally that's going to be provided online, part-time, asynchronous, so that they continue practicing in the pharmacy. They don't need to come to Halifax. They are able to complete their educational requirements and then become licensed. And once licensed, then they can be delegated and accountable for technical activities, really freeing up the pharmacist's time.
Time for questions has elapsed. Thank you so much, Ms. Swicker, for your time and your presentation and answering the questions. Thank you. So I'll ask for our next witness, Jennifer Hemian and Mr. Baxter. Welcome back. Just a switch of seats. Yeah. Okay, we will, if you could introduce yourself, how you'd like to be addressed during questions, and if there's an organization that you represent. Thank you. Ms. Hemian.
Good afternoon. Thank you for this opportunity. Please recognize me as Ms. Hemian or Jennifer. And I'm Jennifer Hemian, the Executive Director of the Nova Scotia Regulated Health Professions Network, otherwise known as the Network. By now, you've already heard from the majority of Network members with suggested amendments to Bill 265. For the most part, you're going to hear a summary of what you've heard today from me. I've circulated my notes, but I am going to digress. I would like to expand upon some information to address Ms. Regan's questions about risk of harm. The network, first to introduce the network whom I'm representing, is a network of 21 regulated health professions in the province. The Minister of Health is also a member of the network and participates in the network via their designate, the Department of Health and Wellness staff. Through network initiatives, the minister and regulators collaborate on regulatory initiatives. This collaboration demonstrates regulatory bodies' accountability to government and our commitment to enhancing regulatory processes in this province. Our provincial counterparts are envious of our model of networking with the Department of Health at our table. Again, I've circulated a script, but I will digress, and I do encourage you to refer to my notes to elaborate on some of the points today. I'd like to focus on risk of harm of professional activities of regulated health professional scopes of practice. Professions are regulated because there is a risk of harm to the public in providing professional health care services. As a patient, do you want to receive care from a self-taught psychologist? Do you want assurance that your occupational therapist has remained current 20 years after they completed their initial training? Do you trust that your dentist's credentials have been verified and are substantially equivalent to Canadian standards of education and expectations? Do you want your nurse's identification verified so you don't question that your nurse is who they say they are? Do you expect that your dietitian can understand and communicate effectively in English? Do you trust that your physician has had conduct history assessed and is safe to practice? I'd like to expand upon implications to incompetent care. And this care may not be incompetent in a healthcare professional's original jurisdiction, but may not compare to Canadian standards. I am a dietitian by profession, and there are aspects of harm that may be evident in any healthcare profession due to errors, omissions, misdiagnoses, and treatments that aren't evidence-based to the quality of evidence expected in the Canadian healthcare system. As a dietitian, to focus on an aspect of harm, insufficient nutritional quality, quantity, insufficient, not meeting nutritional requirements impacts recovery rates after surgeries. Malnutrition impacts mental health, dementia progression, malnutrition, wound healing in long-term care facilities, impacting growth and development of infants and young children. So there are definite impacts to and harm from incompetent practice. Those are just examples of clinical examples of care. I mean, you've already heard about the risks associated with care that does not involve informed consent, a patient-focused care that may not be the expectation in other jurisdictions. I'd just like to highlight that addressing the blankets recognition of other jurisdictions, the practice of physiotherapy in one country may be equivalent to the expectations in Canada. For example, though in dietetics, perhaps dietitians in a country may only reflect food service management and lack any education or training related to clinical competence. Again, please refer to my notes. But the network is in support of the Act, has proposed amendments to involve the expertise of regulators and the professions to support and strengthen this piece of legislation.
Thank you very much, Ms. Hemian. Is that how I pronounce it? Perfect. Excellent. Thank you. I have MLA Regan? Yeah.
Sure. Thank you very much for addressing what was my big concern when I heard about the bill and was looking at it, because of my experience with the Department of Labor. I know that someone who is accredited to perform certain actions in one jurisdiction doesn't mean they should actually be performing, and I say set of actions, but they would be licensed to do something in one jurisdiction, but what that entails in another jurisdiction could be completely different. And so I'm deeply concerned about this because, you know, we have, they're very different from different countries. Some countries are very similar to ours, and we've seen that, you know, for the example of physicians, in a number of jurisdictions, the training is very similar. In other places, it is not similar, and harm can result. And so thank you for coming and explaining that to us. If there's anything else you'd like to add to what you said, we'd love to hear it.
Ms. Hemian?
I don't think there's anything else to add that my colleagues haven't already spoken.
Okay.
Would you agree?
I would agree. MLA Hanson.
Thank you, Mr. Chair. Ms. Hemian, I have a question about timing, because we see that this bill is being put forward in this this session. I'm just curious to know how much time did you know, the 21 groups of folks have to actually set eyes on this and have time to make amendments to put forward for today?
Ms. Swicker. I'm sorry. Ms. Hemian. My apologies.
Mr. Chair, we learned of this legislation on my way home from Jamaica on Monday. So we have been addressing and reviewing with legal counsel and our partners since Tuesday morning.
Can I have a follow-up?
Sure. Yeah. MLA Hanson.
Thank you, Mr. Chair. If you had a lot more time to really take a look and take a really good, I mean, the amendments are clear, but if you had a little bit more time, do you think that that would benefit what this particular bill is going to address when it does become a piece of legislature?
Ms. Hemian.
I'm going to refer to Ryan with his legal expertise, whether extra time in this critique would have resulted in any other amendments requests.
Okay, Mr. Baxter.
Thank you, Mr. Chair, and thank you for the question, MLA Hanson. I think myself and a lot of colleagues and I are probably in sleep deficit because this was a pretty quick turnaround. We have proposed amendments that we think are workable and would make the legislation mitigate risk to the public, which is our only interest. It's the only reason we're here today. So we certainly would have benefited from consultation prior to the language going to first reading. As we recognize this morning, that's not always possible, but due to how far-reaching this legislation is, we think taking the time to achieve the goals of government would have only strengthened the language in the end. So thank you.
Thank you.
Are there any further questions from our members? Seeing none, I'd like to thank Ms. Hemian and Mr. Baxter once again for presentation. Thank you. I will now ask for our next presenter, Patricia Grant. Welcome, Ms. Grant. Thank you for coming this afternoon. If you could state your name for the record and how you would like to be addressed during questions, that would be great. Thank you.
Yes. My name is Patricia Grant. You may address me as Patricia or, in your case, Mr. Chair, Ms. Grant.
Ms. Grant. Okay.
That will make it easy for my last name.
Wonderful. Thank you. Ms. Grant.
Okay. May I go ahead? Okay. I come today representing the public in Nova Scotia, or not representing the public. I'm sorry, you do that. I'm representing a member of the public and my own. In full interest of disclosure, this is not my first time at this particular rodeo. I've had the privilege to address law amendments previously in 2007, where I supported the Dental Hygienist Act of Nova Scotia. And subsequent to the passing of that act in the House, I held the position of registrar for the college since I left in 2017, so for 9 years. Today I present as an individual in Nova Scotia who has reached those years in life when access to safe and timely health care becomes more critical than ever. We know it is the coming in and the going out, which are the two periods in a person's lifespan when they are likely to put more strain on the healthcare system. I was disappointed when I heard that this act had come to the floor without consultation from the people, the regulators, who have presented us with safe health care and who actually protect the public under their own legislation to make sure that the people who they license are in fact competent and safe. I want to address one thing the regulators probably didn't say, although one or two hinted. Several, for the committee members and the public, it is important to know that regulatory colleges in Nova Scotia, especially the newer and smaller colleges, operate solely in funds they bring through fees attached to application, registration, licensing, and annual license renewal. The smaller and newer colleges have no fat in their budget, generate very little reserve for discipline actions, and no deficit budgets are possible. Staff in these colleges usually consist of a registrar, maybe full-time, and an admin assistant, maybe full-time. They work very diligently, and their boards are very dedicated. So I want to note that in the act that's proposed, there is several references to waiving of fees. In a Nova Scotia press release, reference was made to Nova Scotia covering the initial licensing fees for individuals who already hold a license to practice in another jurisdiction in Canada. I presume in this statement they mean the Nova Scotia government and not the colleges. There appears to be a reference on application fees, that there would be no application fees, that application fees should be waived. It will be difficult for small colleges to balance their budgets, and if they continue to lose control over their ability to collect administration fees. In the worst case scenario, they would forfeit their mandate entirely back to the minister. So we hope that those fees will be reimbursed as stated. The public will be well served if the outcome of this bill is that more healthcare professionals come to Nova Scotia. But my question is, will the public be as well protected? Actions taken in haste and without consultation, even with the best intentions, have unintended consequences, as we heard from many of the regulators today. Items in Section 8, subsection 1, A to D, and F, all of the regulators mentioned or spoke on. These are the ones concerning licensing of professionals from other countries. Prior to being a regulator, I was an educator and worked with international students in dentistry and dental hygiene who were in various stages of qualifying programs. There are not qualifying programs for every country, but there are some. The skill range was quite vast among individuals and depending on the country. My particular subject area, oral radiology, was not taught in programs in some countries, so that would be a huge gap. However, I do want to go on, but that is the issue. The timeline for identifying and closing gaps in professional education can be extensive. Without those programs, it is difficult for regulators to establish if any individual candidate or applicant meets the standards they have set for public protection. So I ask these questions. Will this bill, if it goes forward as planned without any amendments, will it further undermine the delicate funding situation for some regulatory colleges? Down the road, will it result in disciplinary complaints from members of the public for regulatory colleges?
Order. The time for your presentation has elapsed. Thank you so much. So I'll move it to the members, committee members, for questions, and start with MLA Regan.
Thank you very much for coming in. It's all the more laudable, and we know that you have retired, but felt moved to come in here. And my big concern, and I think is the concern of many people, which is the safety aspect of it, which is completely overlooked. Is there anything else? I know we cut you off before the end. Is there anything else that you would like to add to your remarks?
Ms. Grant.
No, I think that it did cover it. I think that my further question was that, will the changes to the regulatory authorities result in more legal action, which includes the minister and the government of Nova Scotia itself, as they assume a larger role in the regulatory process? So those are the questions I'd like you to each think about as you move forward on this. And ultimately, more legal action results in more costs for the taxpayers of Nova Scotia.
Are there any other questions from committee members? Seeing none, I'd like to thank you, Ms. Grant, for your presentation this afternoon, and have a great day. All right, everyone. We have one more presenter, Mr. Kavanagh. Good afternoon, Mr. Kavanagh.
Good afternoon.
If you could state your name and any organization that you represent, and how you'd like to be addressed during questions when we have that opportunity, please go ahead.
Okay. I'm Dana Kavanagh. I'm with the president of the Nova Scotia Federation of Labour. I can be addressed simply by Danny or Mr. Kavanagh. I do have copies.
Yeah. Oh, you have copies.
Presentation.
So I don't want to start your time. We'll get the copies out and all.
I think I have enough.
Okay, everyone has a copy. Mr. Kavanaugh.
Okay, thank you. Nova Scotia Federation of Labor represents 70,000 workers from various unions in Nova Scotia. While we welcome the measures to restrict the use of sick notes, and I'll be speaking to specifically around the sick note part, we are concerned about several items contained within the bill. First one is we too are concerned about the lack of consultations around the sick note variances that are contained within the bill. We've heard time and time again from our worker members, instead of staying home and recovering, workers are forced to sit in walk-in clinics with cold and flu symptoms to get a sick note for their employer, and it puts a burden on the healthcare system and on the health of a worker. These restrictions mean that more and more workers are forced to show up to work sick because they simply can't afford to stay home. Unlike the federal standards, this government's bill allows employers to demand a note if the employee took at least 2 non-consecutive absences of as little as 1 day each due to sickness or injury in the preceding year. In practical terms, this will mean employers will easily get around the prohibition on medical notes for sickness or injury absences lasting 5 or fewer consecutive working days. We recommend and urge the government to delete Section 5(1)(b) in Schedule B. 5(1), an employer may not require a certificate with respect to an employee's absence from work due to the employee's sickness or injury unless A, the absence continues for more than 5 consecutive working days, or B, the employee has had at least 2 non-consecutive absences of 5 or fewer working days due to sickness or injury in the preceding 12 months. Qualified health practitioner, this bill also puts conditions on the qualified health practitioner who is authorized to provide medical certificates. It specifies that a qualified health professional who is providing a diagnosis, treatment, or care to an employee with respect to the sickness or injury that is causing the employee's absence from work. That falls within the scope of practice of the profession of a qualified health professional, and that falls within the individual scope of practice of the qualified health professional. The federal legislation does not have any of these requirements. It simply defines healthcare practitioner as a person lawfully entitled under the laws of a province to provide health services in the place in which they provide those services. We therefore recommend that Section 5(2) in its entirety be replaced by the following phrase: to A, a certificate permitted to be required under subsection 1 may be issued by a qualified health professional who is providing a diagnosis, treatment, or care to an employee. With respect to the sickness or injury that is causing the employee's absence from work, that falls within the scope of the practice of the profession of the qualified health professional, and that falls within the individual scope of practice of the qualified health professional. A certificate permitted to be required under subsection 1 may be issued by a qualified health professional. A qualified health professional could then be defined simply along the lines of the Canada Labour Code. Accordingly, we delete section 10(1)(a) and (b), which allows the government to make regulations and define qualified health professional. 10(1), the governing council may make regulations excluding classes of persons for the purpose of definition of a qualified health professional. In section 2(b), prescribing classes of persons for the purpose of the definition of a qualified health professional. And in section 2(c), excluding persons or a class of persons from the application of this act. D, for the purpose of section 8, respecting administrative penalties for contravenes of the Act, including prescribing the form and content of the notice of an administrative penalty, respecting the determination of amounts of administrative penalties which may vary according to the nature or frequency of the contravention, and 3, respecting any other matter necessary for the administration of the system of administrative penalties provided for under this Act. E, and defining any word or expression used but not defined in this Act. And F, respecting any matter or thing.
Order. Thank you, Mr. Kavanaugh. The time for presentation has elapsed. I will go to committee members for questions, starting with MLA LeBlanc and then MLA Regan.
Thanks very much for being here, Mr. Kavanaugh. I was wondering, just one clarification on the part of the sick notes legislation, the B part, basically. So when you say you recommend and urge the government to delete section 5.1, oh, never mind. I just answered my own question. I just want to clarify that you're okay with the 5 consecutive days, but you don't like the 2 consecutive absences.
Mr. Kavanaugh? Mr. Kavanaugh? Just answer.
Oh, sorry. Yes, that's right. Sorry.
All right. MLA Regan.
Mr. Chair, I do have a motion I would like to make after Mr. Kavanaugh leaves, but I would like to say, just ask him a quick question. Is it, when you see requests for sick notes coming, is it mostly big companies or small companies? Do we have any idea who is asking for these sick notes?
Mr. Kavanaugh.
Sorry. I think it's all over the map. It's all kinds of employers, but it is large ones that can well afford to pay for the notes, but it is some small ones. But there's a lot of individuals that work a minimum wage job, as an example, who can't afford the note. And I want you to think about how this disproportionately affects women, especially, who sometimes can run into other problems that may cause them to need to get a sick note. So there's, I think we need to think about that, and we should just scrap the idea of sick notes altogether or make the employers pay for them.
I don't see any other hands up at this time. I'd like to thank Mr. Kavanaugh for his presentation this afternoon, and thank committee members as well. MLA Regan.
Thank you, Mr. Chair. I think I was only here for part of the day, but I think we've heard a lot here today. And I think it's really important to Nova Scotians that we get this particular bill right. I think all of us think the intention of the government is laudable, and we support the government in wanting to ensure that Nova Scotians have increased access to health care. But we're hearing from regulators that while the goals of this legislation are laudable, it is flawed. There are problems, and multiple amendments have been proposed by a variety of different organizations. Most of them basically speak to the same issues. And they're not doing it to be difficult. They're doing it out of concern for patient safety. So I would say that we cannot afford to get this wrong. And I move that this bill remain in this committee until it is amended and does not go back to the House until we have amendments come forward that actually address what we've heard here today.
MLA Boudreau.
Thank you, Mr. Chair, and I'll thank my member across for kind of comments on this topic. Certainly, I think I've mentioned it a few times here, both to presenters and to everyone here, to let you know that certainly we wanted to hear from these submissions, and we want to take some careful and thoughtful process to look at those submissions. We've had people from the department here, and we've taken those into consideration. But certainly at this time, we're going to continue on with the process as we've always done, and at this time I won't be supporting that motion.
MLA Regan.
Well, while the honourable member may say this is what we've always done, that's not actually the case. It's not always. Sometimes the bill does remain here. Sometimes it does not report back to the House. And I would submit that we heard a lot of very thoughtful interjections here from regulators who are responsible for the safety of Nova Scotians, and this bill should not be moving forward back to the House without amendments, or I can start proposing them here. I can do that, and we can spend time here, or we can just delay and ensure that the government has time. And I'm assuming the government's, and I take the government at their word that they're listening. I absolutely do. I don't think there's any question about that. But we need to get this right, and this should not move forward. By sending it back in the form it is, you're saying you're okay with it. And my impression from listening to my colleagues is that they are not okay, and the government is not okay. It should not be going back in this form. It is not right. And we have heard from multiple organizations here today that it is not right in the form it is right now. We need to protect Nova Scotians. I know my colleagues sitting opposite me want to do the same thing. They want to make sure that this bill is right, because we cannot afford to get it wrong. And so we can decide that you don't want to do that, but I'll start proposing amendments, and we could be here all day.
MLA LeBlanc.
Thank you, Mr. Chair. Yes, certainly we are not in support of the bill going forward without amendments. It needs amendments. I didn't realize, to be honest, that we could leave it in committee. I thought we had to make a decision whether or not to move it forward or not, or send it back. I didn't realize we could keep it here. So given that, I think, and given our concerns with the bill, I think that this is a good solution. I mean, there's nothing to stop us from coming back tomorrow as a Law Amendments Committee and continuing the conversation with properly drafted amendments in front of us. And some of those amendments we'd like to see are around the definition of training, definition of scope of practice, more mention of safety, the issues around multiple places, the issue of the member in good standing being too broad, and a better definition of member in good standing, and we don't have in this piece of legislation a definition of completed application. We need to see, and there's a number of other issues that if I had, more time to sit down and propose exact amendments, I would. But I think in order to get it right, as my colleague has said, I would support this motion and, ask that we come back tomorrow with some properly drafted amendments that we can actually take a look at and then move forward into Committee of the Whole House on bills.
Okay. We have a motion on the floor. Is that correct?
That's right.
Okay, so can you repeat your motion?
I move.
Oh, sorry, Mr. MLA Regan.
I move this bill remain in committee until it has been, the concerns we have heard addressed here today are properly reflected in the legislation as a result of amendments.
Okay. Oh. We have a motion on the floor. We're going to call for a vote. Record a vote. Okay. All those in favor? Oh, we got to do. We will start to our left. MLA Boudreau.
No.
MLA White.
No.
MLA Craig.
No.
MLA Sheehy Richard.
No.
MLA LeBlanc.
Yes.
MLA Hanson.
Yes.
MLA Regan.
Yes.
MLA DiCostanzo.
Definitely yes.
MLA Ritzy. No. The motion is defeated. So before we do have some amendments here okay, so can I please have a motion that presentations on Bill 256, patient access to care, now be concluded? MLA Boudreau?
We have.
Yeah, you can do that.
But this is just for presentations. We're concluding. So I will move that presentations on Bill 256, Patient Access to Care Act, now be concluded.
All those in favor?
Aye.
Those opposed? Okay. All right, we do have some amendments. While the clerk passes them out. All right. We have one amendment. I would change as recommended to Law Committee's Liberal Government. I will recognize MLA Regan.
Thank you so much. So the first one you will have on your change sheet, LAC Lib 1, and it is page 1, clause 2, A, line 1, add and promotes public safety immediately after care. And B, line 3, add individual scope of practice and immediately after there.
Right. MLA Regan.
And just for clarity, if anybody is following along on what the nurses had, for example, this is what they had in there. I wasn't here for the earlier one, but this is exactly what's in the nurses one. And these are, the amendments I have here are only the ones we had time to prepare in the short period of time, so.
Okay, is there any discussion? MLA LeBlanc.
Thanks, Mr. Chair. Yeah, I'd just like to say that I think probably, I mean, I won't commit to each one of these amendments because, you know, I want to see them, but generally I think we will be in support of the amendments, but I just want to say that given the lack of time, I think the NDP caucus's approach will be to like digest everything we've heard today and have amendments ready reflecting what we heard for Committee of the Whole, but in general, I think we'll be supporting these amendments, and if they pass, great, then we don't have to do that part.
All right, I'm going to call for a vote. Recorded vote. Okay, we're going to have a recorded vote. We will start to our left. MLA Boudreau?
No.
MLA White?
No.
MLA Craig?
No.
MLA Sheehy Richard?
No.
MLA LeBlanc?
Yes.
MLA Hanson?
Yes.
No, it's not. I mean, yes.
MLA Regan?
Yes.
MLA DiCostanzo?
Yes.
MLA Ritzy? No. All right, there'll be a second sheet coming. All right, we have a second amendment, LAC Lib 2, and I'll ask MLA DiCostanzo to present.
Thank you. Thank you, Mr. Chair. And this amendment is for page number 2, delete clause number 7 and substitute a registrar may practice in an expanded scope of practice area if allowed by the regulations and authorized by the registrar's regulator. Sorry, by the registrar's regulator. Registrants, I'm sorry. Registrants regulator.
Is there any discussion on this amendment? Seeing none, we will call for the vote. Recorded vote. MLA Boudreau.
No.
MLA White.
No.
MLA Craig.
No.
MLA Sheehy Richard.
No.
MLA LeBlanc.
Yes.
MLA Hanson.
Yes.
MLA Regan.
Yes.
MLA DiCostanzo.
Yes.
MLA Ritchie, no. It's been defeated. We have another change sheet coming out. All right, the clerk has passed out a change sheet, LAC Lib 3, and I will ask MLA Regan to present.
So I move that we change page 2, paragraph 8, 1B, line 1, delete the word practitioners and substitute regulators to authorize registrants.
So I'll propose the committee. Any further discussion on this amendment? Seeing none, we will call for a vote and recorded vote. We will start with MLA Boudreau.
No.
MLA White.
No.
MLA Craig.
No.
MLA Sheehy Richard.
No.
MLA LeBlanc.
Yes.
MLA Hanson.
Yep.
MLA Regan.
Yes?
MLA DiCostanzo.
Yes. Yes, of course.
And MLA Ritchie, no. That amendment's been defeated. We have one more being passed out. Okay, we have an amendment, number 4, LAC Lib 4, and I'll ask MLA DiCostanzo to speak to it.
Thank you, Mr. Chair. And this one is for page 3, paragraph 8, 1G, line 1, add, including good standing, immediately after the word act.
Okay, so I'll ask the committee if there's any discussion to the amendment. MLA Regan.
So we just heard from multiple registrars, from multiple witnesses. There's a good reason to have the word good standing, the words good standing in this bill. And again, once again, the amendments we're putting forward make the bill better. We understand that the government wants to move healthcare along, but the people who appeared before us today are the experts on these particular professions. We probably can't throw anything at them that they haven't seen before. And by refusing to make common sense changes to this bill that will in fact enhance the safety of Nova Scotians while allowing for the expansion of scope of practice and allowing for folks to have access to healthcare in new ways is deeply concerning to me. This is a no-brainer here. This amendment is a no-brainer. It was put forward by multiple different witnesses. And the reason we have that is because they're experts. Cabinet, no matter how many smart people you have in cabinet is not, members of cabinet are not experts in these particular fields. And we should not be removing the authority from these regulators and substituting the power of cabinet, because at the end of the day, Nova Scotians will be the ones at risk. And the effects of this may not be felt right away. It may be years down the road when something happens because someone was let in to practice when they shouldn't have been. And we've all seen stories about people who should not have been practicing, who got through for one reason or another. That is the job of the regulator, to make sure that those people get weeded out. And we need to make sure that they retain their authority. And one of the things that they have, whether it's criminality or incompetence, they have underlined for us a good reason for having the words good standing added to this act. Not doing so is abdicating our responsibility. And that's why we should be inserting this in this act today. Thank you.
I have MLA Hanson, then MLA LeBlanc.
Thank you, Mr. Chair. So this topic of discussion started at 11 a.m. this morning, and here we are at 2:39, and we've listened to folks today, most who agreed with parts of this bill. You know, there are some things in it that are actually beneficial to the scope of practice in which this bill will affect. But they also felt that there were some things missing, and the language that was used wasn't as accurate as it could have been. So this is an opportunity for us here in this committee to listen, to open our eyes and hear from the experts. Open our eyes and hear, open our ears and hear from the experts who actually are living this, and this is their breath of their life, to be able to speak for those folks that, you know, they represent in the organizations that they serve. So I'm really concerned as well. In the sense that we're not even pausing to take a moment to just even let this sit in committee, take a couple days to kind of reflect on what was heard today and possibly bring forward some amendments that will actually really reflect what these folks are talking about today, because this is their practice. So I just wanted to put that forward. I think, you know, we do this time and time again, sitting in committee, and it's always the back and forth, and then we get to, you know, back to the House, and it's the same situation without any change. And I think we've heard today from a number of folks that say there needs to be some change. They didn't say that it wasn't good. They're saying it could be better, and this is our opportunity to do just that, make this piece of legislation better.
MLA LeBlanc.
Yeah, thank you, Mr. Chair. From my reading of things, it feels like this particular amendment actually doesn't do what the presenters have asked it to do. So in this particular amendment, our Liberal colleagues have simply suggested that we add including good standing immediately after the act. But there's no definition of good standing, which is what we heard from our presenters, which is that the good standing could simply mean all the dues are paid up. But in fact, good standing must mean a whole bunch of other things. So I don't know how to handle that. So I can't support this amendment, but I would suggest an amendment to the amendment, but I don't know how that works in committee, in law amendments committee. Wait for legal counsel on that.
Right. So you can move an amendment to the amendment. MLA LeBlanc.
Great, so in that case, the amendment to the amendment will be, okay, so it says add including good standing immediately after the act, and then good standing means a practitioner, so add good standing means a practitioner has a current equivalent license issued without conditions, and B, no complaints, disciplinary, or criminal proceedings pending or taken relating to their competency, conduct, or character.
Yeah, good.
Is there any further discussion on the MLA Boudreau?
Thank you, Mr. Chair. And I just, there's been a lot of talk about kind of safety of patients, and, I'm a practitioner who values that extremely well. And I will tell you that it's in the forefront of this government's, mind. And so there will be robust and thoughtful regulations coming in with this act that will make sure that safety is ensured. And so I will leave it at that. Again, I appreciate motions, and I'll leave it there. Thank you.
Okay, MLA LeBlanc.
Mr. Chair, the problem with good and robust regulations is that what happens to the act when another government who doesn't have as great intentions as this government does have, what happens to the whole system then? So we need to be able to debate these things on the floor of the legislature and put them into legislation, bake them into legislation, so that they are not vulnerable to less upstanding governments as we have today. Like yourselves.
MLA Regan.
I would support my honourable colleague's amendment to the amendment. I do feel that it is important to have this embedded in the Act for the reasons she outlined, and regulations can be changed, and they can be changed very easily, and that's the great part about regulations. It's also the drawback here. This needs to be an underpinning of this particular bill. It does not. It should not be something that can be removed with a stroke of the pen of cabinet. It needs to be an underpinning, a crucial element of this bill, and removing it from or not putting it into this particular bill, to me, is a grave error. And with the greatest of respect to my colleague, who I know participates in a regulated profession, and I know is of the highest caliber and is very good at his profession, the fact of the matter is not everyone is. And we need to have this as part of the necessary fabric of this particular bill, and for that reason, we will be supporting the amendment to the amendment.
Thank you.
Okay. We have a motion on the floor for the am I correct here? Amendment to the amendment. We have a motion on the floor, and we'll go recorded vote. And we will start with MLA Boudreau.
No.
MLA White.
No.
MLA Craig.
No.
MLA Sheehy-Richard.
No.
MLA LeBlanc.
Yes.
MLA Hanson.
Yes.
MLA Regan.
Yes.
MLA DiCostanzo.
Yes.
MLA Ritzy, no. So that's amendment to the amendment's defeated. So now we have to vote on the original amendment. MLA Regan.
For the reasons that my colleague from the NDP outlined, I would like to withdraw this particular amendment because I don't feel it goes far enough.
Okay. All right. So
permission of the committee.
So we'll need permission from the committee with a vote, or just consensus? Yeah. Does everybody agree that will? Okay. So it's been removed. Okay. So that brings us to the end of our. Yeah. So I have to. Where am I here? Okay. We have to move Bill 256, Patient Access to Care. to report back to the House, so I need a motion for that. MLA Boudreau.
Thank you, Mr. Chair. So I move that Bill 256, the Patient Access to Care Act, be reported to the House without amendment.
All those in recorded vote? Okay. MLA Boudreau.
Yes.
MLA White.
Yes.
MLA Craig.
Yes.
MLA Sheehy Richard.
Yes.
MLA LeBlanc.
No.
MLA Hanson.
No.
MLA Regan.
No.
MLA DiCostanzo.
No.
MLA Ritzy. Yes. Okay. So that motion, or that's carried, approved. Yeah, there we go. All right. So I will call the Law Amendments Committee meeting adjourned.
Thank you.
Thank you.